even in city of Pune. When I think of RERA, I always feel about, two things. I rather remember two things. One is we have come a far way from the movie Garunda. If you all have seen, it's a very old time movie called as Garunda, where there was a case, there was a story about a person who was, the builder doesn't give him the house and all those stuff. From that times, we have come to a movie which is called Khosla Ka Ghosla, right? So this is the way where we are progressing. And I think with RERA, we are going leaps and bounds ahead. And we have a fantastic opportunity as chartered accountants to be here in RERA because we have an analytical mind. We can really see through what's happening. And we can not only understand the financial statements of the builders, but more so that we can understand what he is thinking, what he is planning. So I think we are all set to have a good practice in RERA. So Amish, you have done a wonderful job by coordinating this, Bhavna. Thank you very much for your coordination along with Prasad. It has been real. Thank you also for calling me here to share my thoughts. And I wish all of you a very happy learning. Not exactly happy, but I'm sure that you will take this opportunity in its right side, the learning, the long way. And we will have many more people practicing in this area, a Noyo area of RERA. Thank you so much.
Thank you, ma'am. So not wasting much time. See Aditya sir, we can start. Thank you.
कल का पीपीटी की कर रहा है नहीं पिछला कल का First of all, thank you for the request of the members. Many had requested me yesterday also. So I also didn't feel good that within 15-20 minutes we have to cover such a huge topic. So I have now 1 hour till 5 p.m. So let us see to it that most of the questions while taking the form itself we can solve. I would thank RCM, Ruta Chitra madam. She's always ahead in taking various initiatives. She had recently taken initiative doubts about the course. And I thank Amish bhai for listening to the members' request. Today the attendance yesterday, I think so everyone were there for Form 3 only. Most of them were interested and they are not aware that we have again conducted Form 3. Now coming to Form 3, let's start with the Form 3 itself. All are aware that this is the Form 3 format, right? Now the conception is that whether this is to be given at the time of registration and when it is to be given. So here this Form 3 needs to be given at the time of registration as well as at the time of every withdrawal. Now in Act it is written every withdrawal, but it is not possible to give it at the time of every withdrawal. So it is to be considered that जभी भी अपना जो limit है Form 3 में, whenever that limit is exhausted or fully utilized, this Form 3 needs to be submitted to the RERA and to the portal. I mean to say to the portal and to the bank. But as I said yesterday, जो quarterly हम लोग update करेंगे, तो उसमें ये Form 3 हमेशा अपने को लेने के लिए better है. Otherwise, what will happen? Developers will be in a rush when the limit is exhausted, and that time we at least take, समझो एक बड़ा project रहेगा तो at least 10 to 15 days, because for the entire scrutiny and bifurcation of which cost needs to be allowed and disallowed, it is very difficult at the inception itself. So यहाँ पे हम लोग को at the time of every quarter we need to obtain this form 3, so our efforts are reduced, and जो buyers है उनके लिए जो अपना form 3 का costing है वो actual cost total हम लोग को हर quarter में मिल जाएगा. That will serve the purpose. Otherwise it will create a confusion, because what happens, due to certain issues the project gets stalled, and most of the stall project if you have seen, वहां पे उन्होंने starting में 2017 में form 3 लिया होगा, because form 3 is mandatory at the time of registration. So they might have taken form 3 at the time of beginning of the registration, उसके बाद अब तक लिया नहीं. So now they will come in two situations. If they receive the notice from RERA, or in the second situation if they require an extension. तो ये situation में वो लोग आएंगे तो it is very difficult to go back and check all the records and scrutiny the same, and they will face the penalties if they have withdrawn the amount without any form 3. So this form 3 is very important out of all the certificates. Form 5 is audit report. That is how much amount is included or how much amount is utilized for the project, वो certify होता है. But इससे developer needs to take this certificate, because यहाँ से हम लोग को amount, we get the authenticity for withdrawal of the amount. So this certificate is very important. Now, as I said, यहाँ पे ये जो to the promoter है, so in this to the promoter, in case of joint development agreement होगा, तो form 3 is for specific promoter. तो main promoter के लिए अलग form 3, and for landowner there is a different form 3. So both should obtain a separate form 3, and it cannot be clubbed, because what happens, there might be certain clashes between the landowner. ये तो होता ही रहता है, because इसको अपने जो data है वो नहीं दिखाना है, उसको जो rates हम बाहर sell कर रहे, तो इसको avoid करने के लिए common form 3 नहीं हो सकता. And in future, as I said yesterday also, that there might be a circular within 2-3 months, that in which case you have to submit form 3, whether developer and landowner. So they might give you situations, and in that case you have to submit form 3. So soon we might see the circular. Now coming to the subject clause, you can see certificate of financial progress of work. So certificate of financial progress of work. What is financial progress? That is the actual cost incurred, the estimated cost, जो भी उसका cost perspective, because form 1 and 2 both deals with physical inspection and technical inspection. But this is the only form which deals with the books of accounts. तो यहाँ पे जो financially वो कैसे project progress कर रहा है, that needs to be evaluated. Now there is a question that whether we can compare form 3 situation with form 1 and 2. Yes, in somewhat manner. Like I said, suppose at the time of registration, the project might be at plinth stage or at excavation stage. So architect बोल रहा है कि 40% work is completed. And in my form, there is a field column called as cost of construction. So cost of construction में अगर मैंने figure include ही नहीं किया, and architect is saying 40% work is completed. So there is a mismatch. So we have to compare with the percentage कि समझो उसने बोला है कि इतना slab हुआ है. So accordingly हमारा जो per square feet construction का rate है, is it matching with that? Some kind of analysis needs to be done. फिर क्योंकि अभी आप लोगों को पता है कि 313 projects में they have sent investigators. तो अगर हम लोग नहीं verify कर सकते तो how investigators will do? Investigators will do this. They will straight away dig up these 3 forms and they will compare. They have the valuation methods. They will see the valuation as on today and they will check the form 3 and form 2 and form 1. So if they can do, we can also very well compare only on the basis of observation that this cost is there on the basis of 40% excavation work, plinth work, कुछ भी हो, उस हिसाब से अपने इसमें changes होने चाहिए. So that is how we can compare form 1, 2 and 3. We have the protection under SS 620, that is use of auditor's expert, the work of auditor's expert, but we cannot rely on his work. So we just need to evaluate, yes, Like someone yesterday asked me that engineer or uske form 3 mein bahut zyada variation. See, then it is a point of issue and it might be highlighted by form 5. Form 5 is having the authority to highlight the issues in form 1, 2 and 3. So form 3 का issue नहीं है वो. Form 5 should highlight कि form 2 के इसमें बहुत ज़्यादा difference है. So that discrepancy very well he can come in form 5. Now coming to the table A, estimated cost of project. Yeah, before that, the subject clause. In subject clause, financial progress होने के बाद, the first line of the certificate, this certificate is issued for RERA compliance. Now, RERA compliance means what? At the time of registration, quarterly compliance, and at the time of withdrawal. So this is together sum up as RERA compliance. In our certificate, if you have observed in all formats, we never had subject clause. अपने पास वो subject clause नहीं था. So to which project we are issuing, that was not known. So they rectified this and they have introduced this subject clause. And the first sentence is very important. See, they have made certain changes and these changes suggest what they are expecting from chartered accountants. So that needs to be taken care of. So this certificate is issued for RERA compliance for project having MahaRERA registration number. If you are giving it at the time of registration, you have to mention applied for. And is based on the records and documents produced before me. So any records and documents is not defined. But circular 2017 में जो आया था, उसमें they had clearly mentioned that you have to verify the bank statement. So and all the efforts is towards your bank statement. But यहाँ पे जो अपना cost आता है, that is from the profit and loss account. Because incurred का जो definition, I will take it while at the time of incurred cost, that is very well defined. So everything, nowhere the books of accounts is defined, but you as a chartered accountant can verify it very well from the profit and loss account, from his books, from the annexures which he have maintained, and from the bank statement. So that is very well can be within our scope and we have to verify that. Now coming to table A, the estimated cost of the project, the estimated cost of the project. So that is one question that whether we can certify estimated cost? Yes or no? Can anyone answer? No. So then we are certifying here. Engineer form 2 में कौन सा cost देता है? Construction cost. We are certifying other estimated on what basis? Promoters represented, that means, but we are certifying. See, there is no issue. Note to committee meeting in 1992, they had clearly mentioned that unless a chartered accountant vouch for the accuracy of estimated cost, he can certify that estimated cost. So we are nowhere vouching the accuracy of estimated cost. Hence, it is very well within our scope. We will not be held responsible for this. Only thing is, whenever developer wants to change estimated cost, we should have appropriate documentation. Suppose due to DC rules, whether change, you know, the FSI is increased due to DC rules. So in that case, whether this estimated cost will change, then what is the authenticated document you require? Can anyone tell me? Additional cost, but और एक चीज है जो लगेगा. Approval of FSI is fine. Plans approval is also, these are, but one more important documentation. Sorry? No. As per section 14, subsection 2, you need 2/3 allottees approval also. Even though it is as per the rules, then also you require that correction as per section 14, subsection 2. So that is a valid document for you to consider that estimated cost. And obviously he has to apply for correction for change on the website by paying 5,000 rupees. Now coming to, I won't go in much detail because you know what is land cost, but the first point, that is value of land as ascertained from the annual statement of rates. See, they have given estimated. So most of them are confused. What according to you the value should be here? Samjho, there are two situations. Either I have purchased land today, or other I have purchased, or I have got the land in through inheritance. So suppose we consider first scenario inheritance. तो क्या होगा यहाँ पे? As per the ASR, everyone on the same page. But what will happen अगर मैंने अभी purchase किया? Actual, whichever is higher. What do you think? Actual value. See, logically, actual value क्योंकि उसने bear किया वो expense. But what RERA says, only it should be restricted to ASR. Why? You would say, अरे developer ने तो खर्चा किया है. Why is it so? It is because suppose मैंने 3.5 करोड़ का land लिया है और मेरा समझो ASR 1 करोड़ है. तो अगर 3.5 करोड़ मैंने land cost में include किया पूरा actual, then what will happen? He will recover his entire land cost from the customer's amount. He won't be accountable towards the end of the project. That is the reason they have said to make developer accountable to the project. That is the reason they have restricted that amount to the ASR. That's the reason behind this. Only he can withdraw till the ASR. अगर उसने कम incur किया, whichever is less, that can be included. अगर मैंने कम amount लिया है, तो यहाँ पे कम amount आएगा. लेकिन it is maximum restricted to the ASR only. Now you would say अगर inheritance है, so obviously he had hold the land. He had hold the land for so many years. He could have sold it on to the outside market. So he will get the benefit of the ASR Act. So that's it is dependent on two different situations, but it is restricted to ASR. They have completely replaced the explanation 1. And in that, earlier it was on the actual cost basis, many elements were included, but now they have restricted it to ASR. Okay, can we move forward? Yes. ASR value ends on the date of the certificate. We have to consider that. Yeah, so it should be restricted to ASR only. Yes, it is purchased, right? See, TDR cost is allowed, but what he's paying against that land, then it is restricted to ASR. But later on, what you can do, once that ASR is also exhausted, I would suggest that you can allow him on certain proportion of the milestone achieved, further cost, but not at the beginning. That's for sure, because it is implemented into rules. Because what is the ideology is that it should be restricted to ASR, as he's well aware about the risk and rewards. So if he's buying today, he knows that he cannot recover the entire land cost from the buyer's money itself. He has 30 and recover the land cost from 30%. So that is restricted here in rules as per explanation 1 to rule 5. Okay. Now moving forward, we have premiums, all sort of premiums you can include. Then estimated acquisition cost, any other premiums payable. Now under rehab scheme, the cost of construction of rehab building will only appear here. Rehab also includes redevelopment. So any units allotted to the tenants, those component construction cost will be included here. So that is very well allowed as a land cost, and you can include it here again. Now earlier this cost was comparable with the estimated and actual cost of CA, उसमें whichever is lower, but उसमें problem क्या होता था कि जो estimated cost है, it was always used to higher. तो इसमें क्या हो गया कि वो comparability बराबर नहीं मिलता था, इसके लिए इन्होंने वो table A and table B separate कर दिया. So now only the estimated cost of construction cost of rehab building will be included here. Next, any transit accommodation or any legal or illegal occupants को हटाने के लिए जो भी cost है, that will be included here. And Now, at the last, any other cost, including interest estimated on the borrowing done specifically for construction or rehab component. So any interest estimated that on the borrowing, especially for rehab component. समझो SRA का जो finance होता है, SRA में rehab component के लिए construction finance मिलता है. On that interest you can estimate and you can include it in here. So that is allowed, and this total sum up at land cost. I hope everyone is clear about the land cost. Any further issues? Yes. Okay. No. Sorry, land cost. Yes, he will consider. Land cost is for developer is 0. The landowner will consider as per ASA. That is all. Though they are partners means what is the type of agreement between them? Is it a development agreement or partnership agreement? What? Development agreement. So in that development agreement, and who is the owner? Title किसके पे बना? Title जिसका title certificate is very important, and he is giving development. He will include that as the land. Yes, because he's the landowner, so he will include it as a land. See, now that is the issue. So one important issue is in this, whenever as per the section 3, they have clearly mentioned that whenever the project is developed into phases, you have to register each phase as a separate. But sanction plan देखोगे तो वहां पे कहीं पे एरिया वाइज बाइफर्केशन नहीं, इसीलिए जो डिस्प्यूट चल रहा है वो एक बड़ा डिस्प्यूट है रजिस्ट्रेशन. और रेरा इज सेइंग there is no way I can figure it out from the sanction plan कि ये प्लॉटिंग है, नहीं ये प्लॉट है उसका अमाउंट है so and so and इसका इतना एरिया है. तो ये जो एरिया का बाइफर्केशन नहीं होने की वजह से वो टोटल लैंड एरिया पकड़ता है. So in that case, what you can do, you can have a certain, on the basis of the FSI available, you can have certain ratio. And on that basis, you can divide. But it is, there is no, I mean to say, scientific backing for that. That stand can be taken by the developer, and if you allow, you can mention it that. Based on this, we have allotted this land to this building and to this building, and accordingly, the cost of construction. तो क्या होगा कि हर प्रोजेक्ट में हर फेज में उससे पूरा रजिस्ट्रेशन फी भरना पड़ता है, जिससे वजह से डिस्काउंट. $100% applicable only for ongoing. अभी वो 100% criteria है ही. On new projects के लिए 70%. तो वो जो मैंने कहा बोला you have to define it properly. Because ऐसे भी हो सकता है कि प्रोजेक्ट सी में 3 बिल्डिंग है, 3 में से 2 हो चुके हैं और अभी एक ही है, तो वो पूरा लैंड कॉस्ट में वापस नहीं ले सकता हर फॉर्म में. That is, we won't give you true picture. So you have to divide it compulsorily on basis of certain that can be obtained from architect. We will give you, and on that basis you can do it. Yes. Then all the premium needs to be in time. So the amount will be fixed at the time of registration. He wants, if there is a substantial increase, because many times there is a constant figure also for 2 to 3 years. So if there is a substantial increase, then he has to apply for change. Then only we can include it. Otherwise, that is amount will remain same. Yeah. There won't be any change. We are not together adopt anything which is not the estimated cost. First, we have to change it through application for change, and then only we can include, because there are only two reasons through which he can choose. Either it is a typographical error or there is a order of some order. So ये दो सिचुएशन में ही इसको चेंज करने वाला. See, if it is तो कहते हैं अगर मैं प्रोजेक्ट शुरू हुआ और 2 साल बाद टाइपोग्राफिकल एरर निकाल रहा हूँ तो समवेयर दे में तो हैव इट अगर इनिशिएटली 2-3 महीने में मैं टाइपोग्राफिकल एरर कर रहा हूँ you can understand. So they will demand for authority, and nowadays they are for any application for change they are demanding certain additional documents. Even there is समझो पार्टनरशिप फॉर्म है अभी एलएलपी में कन्वर्ट हो रहा है उसके लिए जो सेक्शन 50 का प्रोसीजर यू हैव टू डू. And even from partnership form to LLP, there is no additional partner. You just don't require to third permission, but all other things you have to go through the same procedure. You have to take approval from public. Now coming to actual cost, everything, whatever is estimated exactly, you have to include the actual. Only differences in include the comparison is between the form 2 actual cost of construction and form 3 actual cost of construction. So whichever is lower, that needs to be included here. Rest everything remains the same. So actual में कोई भी difference नहीं है. Now end में वो चीज expenditure towards taxes and fees charges. So other than income tax, GST is allowed because GST का अगर credit नहीं मिल रहा then it becomes cost of construction and incurred expenditure interest. The interest to any financial institution or NBFC that is allowed, plus unsecured loan पे जो interest है that is also allowed. Because sorry, you have used their money. Everything amount is paid. Till the only thing is interest on any compensation. अगर कोई भी दे रहे allotted scope, तो RERA authorities ने बोला है कि allowed है. As per circular 2017, but tribunal के judgment में लिखा है it is not allowed and the promoter has to bear it from his own pocket. So those ऐसे जो disputable है we have to wait for some time. And circular, however, tribunal judgment is more reliable than this. So it is you need to follow that. So you can give a disclosure and the reference also. Then he has to get it changed. It is because of what? Certain parameters might have to have the estimated and have the actual cost. So you have to compare. And then you have to tell them, you have to give the disclosure due to this heads are changing, due to this escalation or anything. And it is allowed. There won't be an issue. As you said that there are only 2 options for changing the escalate cost. Yeah. So this one should be selected in that. It should be by the order only. You have to select the order, but you have to give disclosure that some see, order is से order cost of construction change हो रहा है. ऐसे जो elements premium change हो रहा है. तो ये जो elements है, इनके लिए order pieces करेंगे. तो समझो दूसरा कोई है जिसका मैंने predict नहीं किया था और बाद में increase हो रहा है, जो GS के है. Now GS also we have the units in hand. We know how many units are there. We have certain idea. We can predict. These are units we have to explain, and if explanation is proper, then they will give you the thing. And what happens is when the interest cost usually exceeds whatever I had estimated. So already this is the standard scenario. So that scenario also we can take on. Yes, you can mention that the loans that we are paying this interest, and we had initially estimated that project will be completed this time. So now the interest element is increasing. So that is all. income. Not exactly paid. As per the ENM में जो credit होगा interest, that element is form part of your form. Yeah, so total amount which you show in your PNL, that amount will come in form 3. Ultimately, your form 3 is equal to your PNL. So उसमें जो cost है, there is only one definition of it, that the product or service for the invoice is received, or product or service for which payment is received. Sorry?
That says that whatever you have paid to LBFC, accumulated, then it will be allowed.
Okay, so if that is allowed, then here also it is allowed, no?
Paid plus payable. Maybe some.
See, LBS paid means you have received the service. You are paying it, you are using the money also. So here they are also allowing whenever you pay and you have received the product or service.
Not paid. 3 quarter I have paid. 4th quarter is payable. In profit and loss account, 4th quarter is payment is shown. But in the actual income tax says only 3 quarters will be allowed. Because 4 quarters you have provided, not paid.
Correct. But here, paid plus payable both are. Right. So your income tax, most commonly there are elements, but here they are giving you on the basis of payment also. So if you have received the service and you have paid, and on that also you can use it. Sorry? Yeah, category fees and everything is included. See, there is no issue with you the heads. Yeah, so they won't, I will say, अगर by chance तुम्हें उनका ऊपर में मिल गया, so there won't be an issue. Yeah. See, what I usually suggest, estimated का जो bottom में total है, उसको target है. अगर उससे भी ऊपर जा रहा है ना, तो change of estimated. क्योंकि तब तक का जरूरत है, वो इंट्रा है, is very well possible, not an issue. Sorry? You can include it. What is the issue in that? हाँ, तो for 80 में क्या 80 में issue, you have the present income, you have paid the amount, no? You have the liability incurred, so your income very well built in. And even the banks are insisting, in case of present period, the banks are also insisting on that. You give the entire balance sheet, we have to move. And developer, I don't think so. Because it might be a very small developer, most of them are providing the others. Okay. Now next, the total cost of the project, that is the actual cost, proportion of the cost incurred. That is the actual cost incurred only, that you can do. They are not recovering them, then it becomes a cost. Amount which can be withdrawn from designated account, that amount is the actual cost incurred, and you will get amount withdrawn till date of this certificate from that designated account. You have to subtract and you will get the net amount which can be withdrawn under this certificate. So your withdrawal should always be restricted to the limit provided in this particular certificate. Now coming to table C, in table C you have receivable. See, I was talking that this table is not applicable for individuals. Why? There is no backing in it. Rules are not yet amended. But RERA authority have come up with the order and this table is applicable. They have removed earlier उसमें ongoing point लिखा था. वो ongoing point निकाल दो, मतलब ये table applicable in this table. रूल पर उसका comment होना बाकी है. तो अभी यहाँ पे the unique consideration as per element of letter of announcement है. Carpet area, that is the RERA carpet area to mention, and amount received and balance facility you will get. But this is only for representation purpose. There is no issue at the time of registration, no one will judge your profit or loss on this basis. And unsold inventory again, similar way, you have to mention the capital area and the unit consideration.
This table C is okay. There is a one start and return. Does not include pass-through charges.
Yeah, all the maintenance and whatever you are collecting on behalf of some factory authority, those charges are not in. So any refundable deposits, any kind of maintenance, share application money. So these type of deposits which you collect, it is only on the basis of some authority or act you are collecting in the past.
Don't they interest collect development charges, etc.
Yeah,
We don't include it here.
mostly the development charges are high, there is a bifurcation. Because including clubhouse charges, some type of charges will be form part of this. But other which are only side application money, so that they are using money.
It's not amount.
Yeah.
Major amount is development charges, is 2 years, 6 years, maintenance charges. Or say, club members, say,
So although advanced maintenance charges is more fun. Battery received amount में TDS deducted किया है. You will get the final amount which is taken to be taken and everything. Yes, okay.
not going to get what account to from they
Amount we want, it is from the inception you have to calculate. Yeah, we will change later on. Earlier we were only that. So now अभी designated है तो वो continue करना है जो पहले का सर्टिफिकेट. जो पहले के सर्टिफिकेट पे वो चलता आ रहा है वही करना है. क्योंकि ये बाद में उन्होंने चेंज किया है. So that doesn't अभी ऑनलाइन में वो लोग कंसीडर कर रहे हैं कि बहुत कम परसेंट है अभी. तो उसमें जो फॉर्मेलिटी चल रहा है वो वैसे ही करना. Not any. So it should be always from inception of it. सबने डेजिग्नेटेड वर्क कर दिया है तो अभी ऑनलाइन में भी बाद में तो उन्होंने रेरा बैंक अकाउंट ओपन किया ही तो दैट दे आर कंसीडर्ड उसके पहले का जो विड्रॉवल्स है वो भी पार्ट आएंगे क्योंकि हम लोग पूरा प्रोजेक्ट का पार्ट नॉन तो ये नॉट पॉजिटिव तो यहाँ पे जो मेरा ये बॉटम में लिख रहा है आई एडवाइस सर्टिफाइड दैट रिक्वायर्ड प्रोपोर्शन ऑफ मनी एज स्पेसिफाइड इन द एक्ट इज कलेक्टेड फ्रॉम एनोटीज एंड बीन डिपॉजिटेड इन डेजिग्नेटेड यहाँ पे एक्सेप्शन है हाँ उसका एक्सेप्ट दिस अमाउंट या एवरीथिंग अदर अमाउंट इज इंक्लूडेड इन द Yeah. Right. See, ultimately what you have to do, ये जो received amount दिख रहा है ऊपर table C में जो 5 number का received amount है, it should exactly match with the deposits. Because it is received till date, it is deposited. But ये होता नहीं है. तो उसके बीच का difference वो आपको यहाँ पे table में देना है. Got it? Sorry? Yeah, amount वहाँ पे तो total आएगा बिल्कुल received amount because it is against the agreement value. But what you are certifying है उस received का 70% is deposited in there. What is it? It is really mentioned that any amount for data, elimination and other funds. If it is any cost, obviously. Yeah. There is no bifurcation aspect. What we do with that? Okay, on the TDS agreement for the stamp duty valuation, whichever is higher, we have to pay.
still recover.
But yes, it can be on that also, no? And GST also that.
So how will you bifurcate? Okay. But then it is debatable. You have to then listen and you have to prove. So it is very difficult for authorities also when you are deducting TDS, income tax में element पर से तुम आप दिखा रहे हो जो higher है और यहाँ पे आप पता करते हो contract कोई giving this. So then you have to go beyond 950. वो उन्होंने 18% दिया रहेगा लीडर के हमारे they might be very sir. Can you give us two types of returns? Designated and formal. Only one. So whatever we select, we put in that one. Now coming to this table B, I hope everyone is already opening balance. In all the video, we should exactly match with the bank statement. Only thing is when there is mismatch, we have to give a report. And we जो नीचे का दो statement है वहाँ पे एक्सेप्शन भी होगा तो ये स्टेटमेंट अपन बोलते हैं हाँ you are not considering the one's deposit and other is utilization. If these two elements are very important, you have to give any exception to this. Okay, coming to table as means of finance. First of all, this table doesn't give a true picture. अगर मैं आज दिखाऊँ कि estimated में मेरा वो cost नहीं और अगर मुझे प्रोजेक्ट करने के लिए नहीं देना, right? और ऐसा कोई नहीं दिखाता मेरा 100 रुपीज कॉस्ट है तो मैं बोलता हूँ 50 रुपये में कस्टमर से लूंगा 50 रुपये में खुद डालूंगा so no one will restrict in SRA we have what we do at least the developer has to bring the capital for the construction cost of the SRA part that's the mandate otherwise you won't get the permission but here they are not mandating them so estimated and proposed estimated these are these figures are hypothetical and you say every time they have to judge with certificate all the certificates, all the projects which are started before 22nd December 2021, पहला कॉलम कभी नहीं आया, इसमें कुछ भी नहीं आया, because it is at the time of registration, and at the time of registration of both projects, this form was not in the list. So only the two other fields are applicable. So ये जो proposed है, estimated as on date of certificate, you have to get it from the developer. Only we are accountable for that. And most of the CA have received it wrong. So own funds, total borrowed funds, customer receipts, goods for the project, and total funds. ऐसे कभी भी नहीं हो सकता है कि मेरा एक्चुअल कॉस्ट से और मेरा पूरा फंड्स इक्वल हो गए. How is it possible? Because that figure is actual cost equal, and the other amount is how much I have used for that project. So मेरे creditors नहीं, that means अगर मैंने equal दिया है, so it should always tally with your creditors because something is payable. It cannot be 100%, right? So actual cost is the incurred cost, and funds are the actual amount I have paid for the capital inflow for the customer. So this is the difference. Withdrawals. Yes, that should. I mean to say as per the agency map, but most of the other things are there. Withdrawals and loans here, loan business in withdrawal case to go. Rico में map. कैसे होता है? कैसे चाहिए क्या? We are not going to assume. We are talking about how he is going to manage project for them. Every time he has to ask this question to himself, whenever he wants form 3, he has to ask this question, अभी आगे से वो कैसे project manage करें? From this day onwards, how he is estimating कि मैं आगे कैसे fund arrange करूँ? That's the relevance of this particular thing. So we are not going to experiment. We are only accountable.
Same with the first one.
No, not necessary.
No, every time I will have a different configuration. मेरा मैं स्टार्ट में एस्टिमेट कर रहा हूँ, मैं कैपिटल ज्यादा ला रहा हूँ, दूसरे बार में मैं लोन ले लिया तो लोन एक्चुअल फैक्चुअल पोजीशन हो गया, मेरा कैपिटल कम हो गया. So it depends on your estimates are bound to change. Now coming to the last part, that is the table G, audit, any comments or observations. So all your observations should be properly given. When you got TDS is there, you have to mention that most of them are not mentioning this. To be very much, and you have to mention the period also. Which also period will be up there. And when you are from 1 to what is the date, who has signed, who has given. See what happens. There might be situation that registration करने वाला सी अलग है, certificate करने वाला अलग है. दोनों का coordination में वो form वहाँ पे upload हो रहा है या नहीं हो रहा है. So we as a started now the issue form 3, which should do all the papers. It could be हो सकता है बाद में changes हो सकते हैं. There might be we might face. So this is the table which is going to change in case of any decisions. So instead of you ये नहीं करना है कि this fraud, he has done all the diversion. See, we have to write it in a proper way. Chartered accountants are maintaining bank account. अगर रेरा को बैंक अकाउंट नंबर और IFSC यही चाहिए रहता तो वो खुद एक बैंक अकाउंट वहाँ पे जो है उसका नाम और नंबर खुद ही लिख देता फॉर्मेट में. We don't have to disclose this because what happens, this certificate is not available for public for download, but they can go for public inspection and they can make this document as a computer. Even forms are readily available. So this is possible to reach out from the comments and observations of the chartered accountant we have to mention and don't extend your scope. They say section 13 of violation is not within the scope of country. That's the yesterday also. We just have to vouch for the deposit, withdrawal and utilization. These are the 3 elements only we have to download. Otherwise, can 3 or road is beyond me. Any violation of the act is not the responsibility of country. It is the responsibility of independent of auditor in case of companies that and tax auditor maybe a tax related who mentioned it. Or Crown 5 can comment on form 3, form 2 and form. But we cannot extend our scope, and many of them are not still within, which is the biggest mistake they are doing. Second important thing is agreement accepted by promoter. Later on, promoter can deny this. इससे बाद में मेरा रजिस्ट्रेशन नंबर और पासवर्ड सब कुछ इसके पास है, तो उसमें अपलोड कर दिया आउटपुट. तो उसका एग्री एंड एक्सेप्टेड बाय यू नीड टू टेक दैट. एंड इवन as per the code of ethics, many of them have the position of the visual signature of their clients, and they sign their client assume कर लेते कि has given you permission, which is not allowed. You have to take permission. You have the record of email that shall I use this digital signature on your this certificate. Later on, he can deny. So these are the 2 precautions which you need to take while issuing form 2. That's all. Thank you. I hope everyone likes that.
Thank you, for yesterday 50% was completed, today 100 has been 200% completed by him. So thank you once again. For the formal vote of thanks, I call upon the CA Prasad. Thank you.
Hello. Good day, everyone. It's like it is a formal vote of thanks, but I want to say it's like a shark tank of RERA. Means it all are like a sharks of RERA, including Ramesh, Aditya, including the guests which we are have an opportunity to honor today. And I am amazed with the attention and curiosity of the audience. Everyone in the audience is paying so much attention and their questions are like, they are so curious about all the topics and they are asking into that granularity. And at the same time, I appreciate Aditya sir that he has answered each and every question with very calm and composed way, and he has delivered an excellent speech. It's my pleasure to express my sincere appreciation to Aditya for taking his time out of his busy schedule and to share his knowledge and expertise with us. Thank you so much.
We had with us today, Civil Council member, C. Rajkumar Aditya. Sir, please welcome. So I request now people also to come on the dais. Vikram Joshi, sir. Kiran, sir, advocate. And advocate special deal. Also the coordinator. Deepika Patel. Bhavan. I request C. Rajkumar Aditya sir to
Good evening, friends. All the faculties of yesterday, today, and tomorrow, the coordinators. No, I am always fascinated by real estate sector because what I see that there is only one asset, which is the prefix real. Other assets we don't say real plant, we don't say real investment, real diamond, real silver. That means, and this is the only asset where we do not provide depreciation. So, I consider RERA of the real estate sector maybe 5% to 10%. RERA is like a consumer act for the real estate, for the speedy resolution of differences between the promoters and the buyers of the registered projects. I would strongly recommend each one of us. No, I prefer to call the word us rather than you. We should take interest in the whole real estate sector. That means drafting of all documents of real estate transactions, conveyancing, given license, maybe settlement where real estate is involved. The resolution of real estate sector companies. Then other elements like conversion of agricultural into non-agricultural. Giving a title certificate. I'm not raising a question, if no time is available, I raise a question. Can a chartered accountant give a title certificate The answer is yes. See, there are four professionals in common field: CA, CS, CMA, and legal professionals. CA, our exclusive right is to do audit under certain law, from tax, income tax, company secretary audit. CMA cost audit under certain legal under the court. The tribunals are not courts. They are a quasi judicial body. Therefore, in tribunal, all professionals are allowed. Similarly, every aspect, and we must learn about the construction industry if we want to really an advisor in the real estate sector. It's not very difficult. And everything happens twice. First in the mind, and second time in reality. Like one will ask, whether I did work in a RERA, and how we learn. Learning is very easy. You don't take more than 60 hours to become more than useful expert. The fiscal law, business ethical law, and this is a law where you can be a national expert, because the law is a central law, and each state has their rules. I would like to specifically acknowledge that I had invested in one property. I have a lot of research on data. So I said, मेरा देश तो हो ही जाएगा. And then this was the property under construction where the builder had not given the possession, and I filed a RERA case. And the builders did not give a possession. 2 years happened. Karthik gave me a good advice. Yeah, appraise the builder. Say that I am sorry, I am withdrawing the appeal. And first wait the property in possession. After learning thing had happened, another 265. First take the possession. If the project is near the completion, the project is less 5.8%, the cost benefit analysis, whether what to do under RERA, whether what to do under control, which to take, what are the other alternatives available. So this is an amazing sector. The timely, timely, but I made a on 41 opportunities. 7 state labor, cooperative, and real estate is one of them. 8 I have given the national level, and then 27 at the global level. So each one of us are welcome to approach, and we can work jointly how to develop the work. This is practice even after doing. The clause 5, 6, 7 of the first MCS Act, 5 is including the work for and 7 is making the work through activity. Do not apply any good system in India to pure knowledge study. So one can apply with the tools on all systems in that time. Giving one significant point. They have a meeting center, they have our own webinar for knowledge study. But I am seeing term by seeing our expertise. Rather than saying that, I am a RERA expert in Maharashtra or RERA expert at national level, become a thought leader, become a visible. So become a speaker, writer, online platform, writer books. And each one of us, God has given us a category, our brain, which is one out of the 78 organs who God has given. We have 100 billion neurons. So we have an immense capacity to work. I invite each one of us to connect with me and work on your case. Thanks for this time. Thank you very much.
It's always pleasure to listen to your thoughts, your contribution to the profession, and your activities on day-to-day going on where I am also in many of your WhatsApp groups. So One round of applause to CA Rajkumar Aditya, sir. Now, not wasting much time, I request CA Deepika Patel to introduce our today's three speakers.
Hello and good evening, everyone. Our next topic of discussion today is a forms of legal entity under RERA and its registration process under the MCS Act 1960 and under Maharashtra Ownership Apartment Act 1970. And to shed light on the same, we have with us CA Vikram Joshi. Vikram Joshi is a FCA, CS and visa. He has qualified his chartered accountancy exam in the year 2012. Is practicing for the past 10 years and is a managing partner in Women-based firm PGD and Associates. He has a vast experience in the areas of taxation, audit, litigation, and cooperative sector. He has coordinated in various events at WRC and has been actively involved in various programs and conducted at the institute. Along with him, we have Mr. Santosh, Giri, and he has been working with CA for the past 14 years. And he has handled any number of registration cases over the time, and he has a perfect practical experience to share insights from the sector. The next topic of discussion is transfer of title and legal conveyance. And for that, we have Advocate Kiran Saha with us. Firstly, I'd like to thank her for accepting this last-minute request to present this topic, because earlier this topic was to be presented by Advocate Paisa, but unfortunately he could not be here due to some medical emergency. So firstly, thank you, Kiran Madam, for accepting this on a short notice. And she also has been working with CA sir for the past 5 years and has been extensively working in the cooperative sector. And she specializes especially in the field of conveyance and conveyance. So with this very brief introduction, I firstly tell all the members to kindly welcome the speaker with a big round of applause. Now I will request Anish sir to kindly present the momentum to the CA Vikram. Sorry, I'm so sorry. I'll request Rajkumar sir to kindly present the momentum to Vikram. Yes, so present the momentum to Kiran Madam. Now I will request sir to present the momentum to Santosh, sir. Sir. Now I would request CA Vikram to kindly proceed with the question.
Hello everyone, I am here today to discuss about the topic forms of legal entity and its registration under the MCS Act and the Maharashtra Ownership of Apartments Act 1970. Can anyone in this august gathering tell me what comes to your mind first when you look at the title of this topic? I can't hear you. Okay, cooperative society, anyone else? Okay, a bit. Anyone? Let's make this session an interactive session.
Yes. Yes. You were saying something, sir? Huh? Okay. Yes, let's begin with the session. To my mind, on any topic, whenever I get to see, I play some kind of KBC with all WH type questions. What, when, where, why, how. So let's ask this question to this topic as well. What are the legal entities? When is the registration required? Where do I register it? Why do I register it? How do I proceed with the registration and what is the registration process? क्या करें ये है ना दिमाग में पहले क्वेश्चन आते हैं बाद में बाकी so let's proceed with my agenda for today's session. I have a very limited time because we have to cover many things. So I have categorized my session in 4-5 parts. So first we'll deal with overview. Then what are the legal provisions governing it? Then what are the objectives of formation of the legal entity and as correctly said, association of allotee. How do we form them? Formation of legal entity. Society, a major, what we can say is the major form of entity which is being formulated everywhere is a society. Society, its salient features, types, process, everything as regards Maharashtra Cooperative Societies Act 1960. Condominium, or we refer to it as primarily apartments. Salient features, apartments under the Maharashtra Ownership of Apartments Act 1970, and the differences between the societies and the apartments. This is the overview which we are discussing in this RERA program that we have already dealt with. That RERA is the act, central act, and others follow it. What are the legal provisions here which are involved? Section 4 is the information to be submitted at the time of registration of the project, which includes formation of association of allotee, revocation and lapse of registration. What is the obligation cast on the competent authority in case of lapse of revocation of registration? The most important section we are going to cover here is section 11, subsection 4, clause E. How the association of allottees are formed. Transfer of title will be covered by Advocate Kiran Saha, which would be dealing in conveyance and team conveyance. The major aspect to be covered here is what is the major and primary objectives of formation of legal entities as association of allottees. The primary object is to complete the pending work related to construction, manage and maintain, administer the overall property, negotiate with various agencies related to construction, get pending approvals from the government agencies, raise funds, and obtain conveyance if any from the promoter owner as per the provisions of that. MOFA 1963 had the section 10, which enlisted the formation of legal entity, which has now been featured as 11(4)(e) under the RERA 2016. The primarily we have few categorizations here into the legal entities, which many of the members have already told you. The first we can register with the society under the Society Maharashtra Cooperative Societies Act 1960, and the authorizing authority here is the Deputy District Registrar. Company which can be incorporated under the Companies Act 2030. Condominiums or apartment under the Maharashtra Ownership of Apartment Act. And the registering authority here is the sub-registrar of assurance. And the last option is other kinds of legal entities, wherein we are having association governed by the Society Administration Act table 60, thus under the Bombay Public Trust Act, forms under Indian Partnership Act 32, others which include LLCs, public sector undertakings and government undertakings under an act of parliament. What are the primary features of the cooperative society? One is voluntary association, which what is the minimum person required for registration of a cooperative society? It is 5 persons. capital raised by way of share capital from members and can be additionally funded by banks. Advantages of a cooperative society: easy formation, open membership, demographic management, limited liability, perpetual succession, which we all know as such. Now, very interesting part: types of society. Many of the members are practicing under RERA, also under the Societies Act. So, what are the various types of society we have here in Maharashtra? It is agricultural marketing society, consumer society, cooperative bank credit society, irrigation processing society, crop protection society, housing society, other society. Now we have a categorization of housing society into 5 subcategories: flat owner society, open plot society, tenant society, housing board societies, and premises society. Many of the members might be doing audit of these all kinds of societies in this area. Yeah. What I think is the trust who cannot register the BBT Act. It is registered not under the 1960 Act, it is registered under the 1860 Act. You have to first form under the SRA 1860, first you form a society, and then you go in for BBT Act registration. Earlier, so it formulates through a society first and then a trust. It was the rule earlier. Yes. So, flat owner society. This is the typical society where we live in. It has categories of different purchasers of residential tenements all over the, which are having flats as owners of the society, and the conveyance of the conveyance or the land belongs to the society. Open plot societies, it is a group of individuals acquiring a plot for administering, maintaining, and managing it. Then we have tenant society, tenants of a building acquiring a plot of land with an old building from a landlord to manage, maintain, and administer it. Housing board society formed by an allottees of flats constructed by the Maharashtra Housing Development Board, primarily known as the Housing Board. And the last but residual category, which we can call, is the general category, which consists of predominantly premises, industrial estates, and the commercial premises. Number of members, as per the amended Act, the minimum members required for registration of a cooperative society is 5 members. Ideally, there is no upper limit as such for a registration of a society. Only the limit is capped to the number of flats or the tenements in the society. For consumer cooperative society, the maximum limit is 200. The interesting aspect here is jurisdiction, where ideally you can form anything. You can go with the LLP as also. You can go with a 1-person company also. Because 1 person won't suit there, LLP would be a good option. If you don't want to register it, you can go in for partnership also. If you want to have a registration, you can go in for the registered partnership as well. That will start once I complete it. What? I didn't hear you. So the land belongs to the society. What is the present situation like? Promoter. Okay. Yes, we can discuss it. I'll complete this slide, then we can discuss it. Jurisdiction for registration. It is as per the municipal wards located here in Mumbai. We all the residents of Mumbai are already classified by BMC into various wards, ABC, every ward. So the ward office has a deputy district registrar with itself, who will entertain your application for registration of society. So this part I cover the what all is required for a cooperative housing society. Now I go on a short aspect about the condominium, which is prevalent mostly not in Mumbai but in Pune, where we find condominium and the apartments there under the Maharashtra Apartment Ownership Act 1970. The primary benefit here is that the apartment ownership, the legal title along with everything has, every owner has a proportionate share in the flat along with the land. So every owner, say there are 5 owners in a building, and it has 1/5 share in the land as well as the building. Registration, it is registered with the deed of apartment is registered with the floor plans of the building at the under the Registration Act 1908 with the Office of Sub Registrar of Assurances. It is the same place where we register all our purchase and sale agreements, the district sub registrar's office. Now we look at the advantages of apartments. So few advantages: sharing of expenses, according to value, voting as the percentage of the holding, NOC for sale not required, separate conveyance in the name of the legal entity also not required. Disadvantages: no proper administrative setup. The remedy option available here is the city civil court. No experts for guidance. Only first owner is allowed to attend and vote. For amendment of bylaws, consent of all is required. Less judicial cases. Few apartments are formed. Mortgagee has the first charge on property. Here we cover what are the advantages of cooperative society. Proper admin setup, authority is the registrar. Cooperative court, a separate setup to solve the dispute. Many expert association, books for guidance, joint owner allowed to attend meeting. Amendment done by 75% or 3/4 majority. Democratic setup, society dues have the first charge. Better management, election transfer, assignment, early disposal of complaints, and more than 125,000 cooperative societies have been registered already. Disadvantages covered here: sharing of common expenses over the property, voting rights 1 per member, transfer for all kinds of transfer, you have to first approach to the society. Separate conveyance is required, registrar's intervention is possible, office bearers may dictate terms. So, basic guidelines for formation of society. Apartments we have dealt with those. So basic guidelines for formation of society here are: there should be at least 5 persons. Persons must be from different family. Such persons must be competent to enter into contracts. Should reside in the area of operation. Such persons should be eligible as per the bylaw. Individual forms cooperative societies. The object of society should be promotion of interest of the members, economically sound, and registration should not be contrary to the provisions of the Act. So now we proceed with the checklist for registration. So before proceeding with the checklist for registration, I am reminded of Bhagavad Gita, अध्याय 2 श्लोक 47, कर्मण्येवाधिकार से मां फलेषु कदाचित्। इसमें भगवान कृष्ण ने ये कहा है कि आप कर्म कीजिए, फल की अपेक्षा मत रखिए। तो ये चेकलिस्ट शुरू हो जाती है इसी से कि आप सोसाइटी में एप्लीकेशन डीडीआर में सबमिट कर दीजिए, फल की अपेक्षा डीडीआर करेगा, आपको नहीं करनी है फल की अपेक्षा। तो उसकी फल की अपेक्षा पूर्ति होते ही आपको रजिस्ट्रेशन मिल जाएगा। So this is the exhaustive checklist which I have. So basically it is bifurcated into actually an exhaustive checklist covering 27 to 30 points. So primarily ABC forms have to be filled. Form A is the statement. So we'll just have a glance at what before formation of a society, what has to be done. What is the act which has to be done? Willing and eligible persons who come together have to conduct a meeting. For the conduct of meeting, they have to decide a proposed name for their society. From the members present, they will be appointing a chief promoter. The chief promoter then has the authority and the necessary resolutions are passed to give him authority to sign necessary documents, open the bank account, proposal for name of the society and everything. The chief promoter will then make an application to the registrar for reservation of name of the society. Once the application is forwarded to the registrar office, they will be checking those documents for scrutiny and their internal departmental purposes. Once the scrutiny is done and the documents are found to be correct, then you are issued a challan for payment of the mandatory 2,500 rupees payment which has to be done to RBI. And the application is forwarded for further, the checklist goes on for the document. And once these documents are processed, within a period of 2 to 3 months, you will get the registration in place for your society. So we go through this checklist not in detail, but we have an overview of this checklist. Application for registration in Form A along with the statement of enclosure, which Mr. Giri would take a bit in detail. Code fee stands for ₹50 to be affixed. Information of promoters in B. Information of promoters of proposed society in statement C. Statement of account, model bylaws 4 copies. Bank balance certificate because you need to open a bank account as well in the bank enlisted by the registrar only. So you have no option to open in private banks or मेरे घर के नजदीक SBI है, HDFC है. We have no option because they basically ask you to open in TDCC, MDCC, Mumbai Bank, all district or cooperative banks which are enlisted with them. Detailed scheme of working, RBI challan for payment of 2,500 rupees and all the annexures to it, purchase of true certified copy of the purchase deed, the Satbara extract, NOC from the competent authority. In case of government land, other allotment letters, no objection certificates. Other certificates from the land in residential zone, other zone, 2 copy of the building plan. Then a certificate of the architect, affidavit from the all promoters, 1 affidavit from chief promoter in Y, another in Form Z. And list from the builder for the unsold flats, 2 copy of the agreement made with the people, affidavit of the chief promoter, along with affidavit from the builder in case the promoter is cooperating, not cooperating, and a copy of the, this is the case when it is cooperating, not cooperating. So, I have completed. Yes. That we have to redress the review complaint mechanism under the society that.
Without builder support also you can form the society. There is a different mechanism. कभी कभी कॉपरेट नहीं करते बिल्डर सोसाइटी फॉर्म ही नहीं करते तो अदर वे अराउंड है यू कैन गो अहेड एंड यू कैन डू दैट. No, बकायदा आपको रजिस्ट्रेशन मिलता है सोसाइटी रजिस्ट्रेशन एक्ट में. इफ बिल्डर इज नॉट सपोर्टिंग यू नाउ देन ऑल्सो यू कैन गेट. तो उसका एक्सपेंस थोड़ा ज्यादा रहता है. हाँ वही कंटिन्यू रहता है. यस. नेम चेंज भी आप कर सकते हैं एप्लीकेशन करके. डिपेंड ऑन द मेंबर्स और रेजोल्यूशन. So this is also one of the area where we can have a good practice, hand over and take over. Formation of the societies. 5 साल का we can do the audit. जो भी वो maintenance charges वगैरह रहते हैं. Not wasting much time in the second. Thanks for the opportunity. Thank you, sir. बट मोस्ट इम्पोर्टेंट इज अपने को सोशल रजिस्ट्रेशन करने का रहेगा, तो हम नेम रजिस्ट्रेशन एप्लीकेशन पर रजिस्ट्रार के पास एप्लीकेशन करते हैं बाय द कंप्यूटर अथॉरिटी। डेप्यूटी रजिस्ट्रार रहेगा या तो असिस्टेंट रजिस्ट्रार, जो भी है हर एक, जो जैसे फॉर एग्जांपल मुंबई डिस्ट्रिक्ट में टोटल टीडीआर 4 है। डिस्ट्रिक्ट डेप्यूटी रजिस्ट्रार मुंबई 1, मुंबई 2, मुंबई 3, मुंबई 4, ऑल द 24 वार्ड अवेलेबल इन द मुंबई जुरिडिक्शन। तो अपने को फर्स्ट अपने सोसाइटी रजिस्ट्रेशन करने का रहेगा, तो अपने को नेम रजिस्ट्रेशन का फॉर्मेट रहता है पर MCS Act 1960। नेम रजिस्ट्रेशन एप्लीकेशन में 51% तो फ्लैट ओनर्स का सिग्नेचर साइन होना चाहिए, मतलब इसका एग्रीमेंट फॉर सेल हुआ है या गिफ्टेड हुआ है जो भी है, तो उसका 51% मेजॉरिटी के हिसाब से एप्लीकेशन पे हर एक मेंबर का सिग्नेचर होना चाहिए। जैसा नेम रजिस्ट्रेशन एप्लीकेशन पे उसमें रहता है कि जो नाम हम प्रपोज कर रहे हैं, इसमें टोटल 4 नाम हमको देना पड़ता है सोशल रजिस्ट्रेशन के लिए। मोस्ट इम्पोर्टेंट फर्स्ट, सेकंड, थर्ड, फोर्थ। मेजॉरिटी फर्स्ट नाम हम जो देते होगा उसमें रेजोल्यूशन पास करना पड़ता है, उसमें अपॉइंट करना पड़ता है चीफ प्रमोटर, जो पूरा और इन्फॉर्मेशन जिम्मेदारी चीफ प्रमोटर के ऊपर रहती है। उसमें मिनट बनाया जाता है, उसमें कौन कौन प्रेजेंट मीटिंग में प्रेजेंट थे, कौन से टाइम की मीटिंग लिया है, कौन से टाइम को मीटिंग एंड हुआ, उसमें कौन कौन प्रेजेंट थे, इतना सिग्नेचर रहता है जो नियम से एप्लीकेशन पे रहता है। उसमें चीफ प्रमोटर अपॉइंट करने के बाद बाकी का को प्रमोटर उनका भी साइन देने का रहता है। उसके बाद में उसका फर्स्ट इम्पोर्टेंट चीज है कि जो ओनर ने साइन किया है उसमें फर्स्ट नेम में डालने के बाद उसके साथ अटैच एग्जीक्यूट मतलब एग्रीमेंट फॉर सेल, एक मेंबर का पहला एग्रीमेंट फॉर सेल और अप्रूव्ड रिलीज प्लान वो उसके साथ में एग्जीक्यूट के साथ में तो सबमिट टू द डेप्यूटी या तो असिस्टेंट रजिस्ट्रार के पास देना पड़ता है। उसके बाद में वो रजिस्ट्रार के पास देने के बाद हम जो भी फॉलो करते हैं उसमें त्रुटि निकालते हैं। त्रुटि का मतलब क्या है कि फॉर्म में फिलअप किया हुआ है क्या, उसमें की प्रमोटर अपॉइंट किया है क्या, मीटिंग किया है क्या, रेजोल्यूशन पास किया है क्या, रेजोल्यूशन में प्रपोजल किसने डाला, किसने अनुमोदन दिया, ये इसकी जानकारी पूरी फिलअप वो फॉर्म में फिलअप करने के बाद वो बोलते बाद में अप्रूव्ड बिल्डिंग प्लान सेटिस्फाई है क्या, उसमें सीरियस नंबर है पार्ट कितने है क्या है, सीरियस नंबर या सीरियस नंबर वेरिफिकेशन हो जाता है। वो अप्रूव्ड बिल्डिंग प्लान में साइन किया हुआ है क्या, डिजिटल है, डिजिटल होने के बाद वो भी वेरिफिकेशन करते हैं। साइन नहीं रहेगा तो सीधा त्रुटि निकालेंगे कि आपने जो सोशल रजिस्ट्रेशन फॉर्मेशन के लिए अप्लाई किया है उसमें आपका अप्रूव्ड बिल्डिंग प्लान में साइन नहीं है और आपको साइन किया हुआ या तो डिजिटल 15 दिन के अंदर या 20 दिन के अंदर आपको छुट्टी आने के बाद 15 दिन के अंदर आपको जमा करना पड़ेगा। ऐसा एक नोटिस निकाल देंगे डेप्यूटेशन है तो असिस्टेंट रजिस्ट्रार। और मेन इंपॉर्टेंट के जो हम एग्रीमेंट देते हैं उसके साथ में चीफ प्रमोटर क्या रहेगा तो को प्रमोटर का उसका वेरिफिकेशन होता है, वो एग्रीमेंट रजिस्टर है क्या, उसका कैबिनेट किया हुआ है क्या, वो सीरियस नंबर और अप्रूव्ड बिल्डिंग प्लान में सीरियस नंबर मैच होता है क्या, टोटल फैक्टर्स एरिया उसका पूरा वेरिफिकेशन होता है। फिर आपने एप्लीकेशन फॉर्म पे कोर्ट के 50 रुपए का लगाया हुआ है क्या, हम सब गलती से 10 रुपए लगाएंगे 20 रुपए लगाए तो भी वेरिफिकेशन फैमिली फॉर्म में टोटली कि आपने कोर्ट पे 50 रुपए के 10 रुपए का कोर्ट पे लगाया, उसके लिए आपको फिर 40 रुपए का या 50 रुपए का आपको कोर्ट पे लगाना है as per GR, as per notification, as per MCS Act 1960, 1980 का GR रहेगा। रेफरेंस में डालते हैं कि कौन से अंडर से कौन से सेक्शन से वो कोर्टी आपको लगाना चाहिए। उसके बाद में वेरिफिकेशन होने के बाद डेप्यूटी आपको 1 महीने के अंदर या 20 या 25 दिन के अंदर आपका डॉक्यूमेंट वेरिफिकेशन होने के बाद आपको एक ऑर्डर देगा, जिसमें जिस लोगों ने साइन किया हुआ है उसका अप्रूवल डाला है 7 लोगों ने, 8 लोगों ने, 9 लोगों ने, 15 लोगों जितना भी है टोटल मेंबर, उसका हर एक का एक बैंक की प्रमोटर के नाम से ऑर्डर निकालेगा रजिस्ट्रार, असिस्टेंट रजिस्ट्रार या तो डेप्यूटी रजिस्ट्रार। उसके बाद में उसका पर्टिकुलर जुरिडिक्शन के हिसाब से जो बैंक रहेगा वो बैंक में आपको आपके की प्रमोटर के साथ में 3 लोगों के साथ में अकाउंट ओपन करना मतलब सोसाइटी का, जिसमें नाम रहता है प्रपोज करके मतलब नियोजित, जो हमने नाम डाला है वो फर्स्ट वाला रहेगा, वो नाम से ऑर्डर देगा के अंदर। तो आपको
वो हमने जो नियम से एप्लीकेशन फॉर्म फिलअप किया हुआ है उसका ओरिजिनल कॉपी बैंक मैनेजर को जमा करना पड़ता है या ओरिजिनल दिखाना पड़ता है कि हमने ये रिजोल्यूशन हमने ये एप्लीकेशन डाला था, ये आप इसके अंदर ये रजिस्टर में अभी कॉपी है, एक बैंक का कॉपी रहेगा, एक की प्रमोटर का कॉपी, अच्छा 2 कॉपी रजिस्टर रहता है, उसमें की प्रमोटर का कॉपी जो रहता है ऑर्डर वो उनके पास रहता है, सोसाइटी के पास की प्रमोटर के, और जो बैंक का कॉपी है वो बैंक अपने पास लेगा, उनके पास लेने के बाद वो वेरिफिकेशन होने के बाद वो फॉर्म लेंगे, फॉर्म देने के बाद इसका चीफ प्रमोटर के नाम से पूरा नाम फिलअप करके ये फिलअप करके जैसे एक बात में बोलेंगे आपने जितना लोगों का प्रपोजल डाला है, जितना लोग आपके एबीसी फॉर्म में साइन किया हुआ है, वो लोगों का आपको शेयर कैपिटल और इंटरेस्ट फी पे करना पड़ेगा, ऐसा बैंक वाले बोलते हैं। तो हमने नेम पे एप्लीकेशन में 10 लोगों का 20 लोगों का जो नाम डाला है टोटल प्रपोज जितना टेनेंट है उनका हर एक का शेयर कैपिटल 500 प्लस एंट्रेंस फी 100 रुपीज वो आपको बैंक में जमा करना पड़ता है टोटल, जितना लोगों ने साइन किया है उसका हर एक का 600 इंटू टोटल मेंबर उनका अकाउंट में सोसाइटी के प्रपोज सोसाइटी के अकाउंट में खाते में पैसा जमा करना पड़ता है। उसके बाद में ऑफिसर जो है मैनेजर अकाउंटेंट एक स्टेटमेंट देगा, वो स्टेटमेंट और ये ऑर्डर के साथ में बाद में 1 महीने के बाद या आपका जैसा सर ने जोशी सर ने बताया आपको एप्लीकेशन में ऑर्डर ए फॉर्म बी फॉर्म मॉडल बायलॉज स्टेटमेंट ऑफ अकाउंट और एफिडेविट दी प्रमोटर कि हर एक का एग्रीमेंट रेडी है, हर एक का एग्रीमेंट का क्या पेड किया है, उसका पूरी जिम्मेदारी की प्रमोटर को रहती है। की प्रमोटर 5 से एफिडेविट स्टैम्प पेपर पे लिख के उसको नोटराइज करके और रजिस्टर को सबमिट करना पड़ता है, जैसा टेक्निकली बताया गया है। ए फॉर्म बी फॉर्म सी फॉर्म हमारा एफिडेविट बैंक में हमारा पेड किया हुआ है, हमारे सोसाइटी में 18 साल का कोई मेंबर नहीं है उसका भी एफिडेविट को खुद देता है, और बाकी का जो मैंने एप्लीकेशन में जो रिस्पॉन्स दिया हुआ है उन्होंने साइन करके दिया है वो पूरा बराबर है, ऐसा करके पूरा फाइल रजिस्ट्रार के पास सबमिशन हो जाता है। सबमिशन होने के बाद 1 या 1.5 महीने के बाद आपके हाथ में सोसाइटी का रजिस्ट्रेशन सर्टिफिकेट और नेशनल कॉपी और नोटिफिकेशन आ जाता है, मिलता है। उसके बाद में आपका सोशल रजिस्ट्रेशन हो गया, उसके बाद में आप मीटिंग लेके वगैरह फिर इलेक्शन लेके आपका क्लोज किया जाता है। उसके बाद में फिर आपका ऑडिट वो चालू रहता है, ऐसे ही प्रोसीजर है। बस नेम से एप्लीकेशन, बाद में आपके ऑर्डर, बाद में पूरा फाइल चेकलिस्ट के साथ में जो डॉक्यूमेंट है तो साथ में आपको सबमिट करने के बाद 1 महीने के बाद आपको एक सर्टिफिकेट, नेशनल कॉपी और एक अप्रूव बायलॉज और एबीसी फॉर्म तो आपको पूरा हाथ में मिलता है कवर के साथ में, तो आपका सोसाइटी रजिस्टर हो गया। उसकी यूनिट के हिसाब से उनका अलग अलग नंबर रहता है, जैसा मुंबई हाउसिंग टेन कोऑपरेटिव नंबर, डेट, ईयर, आपका नेम ऑफ द सोसाइटी, एड्रेस, सिटीजन नंबर, हिस्सा नंबर, उसकी पूरी जानकारी आपको बोलो। हाँ अभी जो मेंबर का क्या पे हुआ नहीं वो खुद एप्लीकेट देगा कि प्रमोटर के नाम से कि मैं कैंप पे मुझे भरा नहीं है, बाद में मैं रजिस्ट्रेशन होने के बाद भरता हूँ तो क्या प्रमोटर देगा, उसकी जिम्मेदारी की प्रमोटर नहीं लेगा। जिसका पेड हुआ है वो एप्लीकेट में मेंशन करेगा तो टोटल क्वांटिटी फ्लैट नंबर पे तो उसका कैंप पे किया हुआ है ऐसा एप्लीकेट में देगा कितना लोगों ने कैंप पे किया हुआ है, जो किसी ने नहीं दिया रहेगा और बाद में उसको कैंप पे करना ही पड़ेगा। उनके ऊपर डिपेंड बैंकर वैसा नहीं रहता है, उनके ऊपर डिपेंड कुछ आगे कुछ जगह एथिक्स कंप्लेंट क्या किया उसके ऊपर डिपेंड है क्या कंप्लेंट, मगर इसका जिम्मेदार पूरा टीम हमको नहीं लेगा क्योंकि उसने क्या मुझे भरा नहीं, उसका मतलब क्या करते हैं उसकी पूरी जानकारी तो वेरिफिकेशन होके एग्रीमेंट किया करके उसका मतलब एग्रीमेंट वेरीफाई करेगा फिर डिपार्टमेंट भी करेगा फिर उसको देगा, मगर बाकी जिसने नहीं भरा है उसको बाद में आज ना तक उसको भरना ही पड़ेगा तो उसकी जिम्मेदारी टीम हमको नहीं है। दुकान बता सकता है क्योंकि आपका एप्लीकेशन जाएगा तो बताएगा आपको भी चीज की हैसियत से आपको वेरिफिकेशन करना ही पड़ेगा कि रजिस्टर है कि नहीं है, कब हुआ है,
उसका रजिस्टर है कि रजिस्टर नहीं है तो उसको बोलना पड़ेगा या तो क्योंकि हम पूरा एग्रीमेंट तो देते हैं क्योंकि डिपार्टमेंट में एक तो एग्रीमेंट और इंडेक्स टू कॉपी इज मोस्ट रिक्वायर्ड और उसके अलावा केवाईसी डॉक्यूमेंट देना पड़ता है। देखिए एक है तो 2 आधार कार्ड है तो पैन कार्ड, तो उसमें आपको जो साइन करते हैं मोटर वगैरह तो वेरीफाई करते हैं इंडेक्स रजिस्टर है कि नहीं वो तो आपको पता चलेगा, ऑनलाइन भी पता चलता है और डॉक्यूमेंट भी पता चलता है कि रजिस्टर है कि नहीं, रजिस्टर रहेगा तो फैमिली पे किया है कि नहीं जरा देखना चाहिए। और उसका रिस्पॉन्सिबिलिटी कौन रहेगा वो खुद ओनर रहेगा फ्लैट ओनर, तो उसको आज में कल वो भरना पड़ेगा मगर उसको एज पर मैंडेटरी 6 एफिडेविट इज कंपल्सरी। जैसा कैंप भी भरा हुआ है एरिया सोल्यूशन के एरिया में हमारा केस नंबर बैंक इलाके में है तो ऐसा की प्रमोटर ही एफिडेविट बना के दे। फिर हमारा 18 साल का कोई मेंबर वगैरह इधर रहता नहीं वगैरह ऐसा ऐसे 5-6 प्रकार के एफिडेविट होता है। ठीक, किसी को फ्लैट ओनर किसी को बना सकते हैं जो मेन फर्स्ट ओनर है, जैसे किसी एग्रीमेंट में जो नाम है एसोसिएशन मेंबर तो फर्स्ट ओनर जो है तो किसी को भी मीटिंग में आप ठीक काम होते करके मुझसे सॉल्व करके अपॉइंट कर सकते हो। ऐसा नहीं कि होगा कि एक ही बार उसका एग्रीमेंट रहना चाहिए तो डॉक्यूमेंट रजिस्टर होना चाहिए मोस्ट इम्पोर्टेंट वो मिलती है। किसी को भी आप प्रमोटर को प्रमोटर अपॉइंट कर सकते हो मगर उसका पूरा ए बी सी फॉर्म ए फॉर्म और एप्लीकेशन ए फॉर्म और सी फॉर्म पूरा हर एक मेंबर का साइन रहता है, मेंबर का फर्स्ट ओनर सेकंड ओनर नेम से एप्लीकेशन बाकी सब डॉक्यूमेंट से एग्रीगेट करके जो हम अटैच कर रहे हैं उसके ऊपर पूरा सिग्नेचर की प्रमोटर करता सेल कर सकते हैं डॉक्यूमेंट ओनली ए फॉर्म सी फॉर्म इज द मोस्ट इंपोर्टेंट ऑल द प्लेटफॉर्म ऑल द यूनियन सिग्नेचर इज द मैंडेटरी कंपल्सरी क्योंकि हर एक एप्लीकेशन में लिंक के एप्लीकेशन डालेंगे तो मेंबर का साइन वेरिफिकेशन किया जाता है। बाद में आपका एग्रीमेंट जो एग्रीमेंट किया है उसकी प्रमोटर साइन देना पड़ता है और उसके बाद में आपको बिल्डिंग प्लान वो भी उसका वेरिफिकेशन साइन चाहिए वेरिफिकेशन होने के बाद साइन ये डिजिटल फॉर्म में उसका वेरीफाई करते हैं ऑनलाइन से चेक करते हैं कि लीगल हुआ है कि नहीं लीगल है क्या उसका नंबर केस नंबर रजिस्ट्रेशन नंबर का पूरे डिपार्टमेंट साइन किया नहीं रहेगा तो फिर छुट्टी निकालते और उनको दिखाई नहीं दिया मतलब अपने बिल्डिंग प्लान तो कंडेंसर का रिड्यूस करके वगैरह तो दिखाएंगे तो फिर भी छुट्टी निकालेगा या तो इन्फॉर्म करेगा कि ऐसा है हमें अपने बिल्डिंग में बना चाहिए कलर में चाहिए तो पूरा हर एक इन्फॉर्मेशन चेक किया जाता है उसके बाद में छुट्टी होने के बाद ही वो आगे बढ़े फिर वो अप्रूव करेगा फिर बैठेगा और थैंक यू। देखो मैं तो अस्सी रहता आप एप्लीकेशन करेंगे तो आपको डुप्लीकेट कॉपी मिल जाएगा मैं तो डुप्लीकेट कॉपी मिल जाएगी आपका टेकन ऑफ आरटीआई के अंदर आप सेकंड कॉपी डुप्लीकेट कॉपी मांग सकते हैं एप्लीकेशन डीआर और टीआर डीआर हाँ मैंडेटरी 500 रुपीज शेयर कैपिटल ओनली इंटरव्यू 100 आप शेयर कैपिटल 1000 भी कर सकते हो 1500 भी कर सकते हो 2000 भी कर सकते हो इंटरव्यू 200 आपको डिपेंड मुझे मैंडेटरी शेयर कैपिटल 500 है उसमें आपको वो भी मिनिस्ट्री जो हम फर्स्ट मीटिंग के लिए यूनिवर्सिटी पास करते हैं उसमें 8 नंबर का फॉर्म करता है कि आपको उसी टाइम पे मीटिंग के टाइम पे आपको शेयर कैपिटल और इंटरेस्ट आपको फाइनल करना रहता है उसमें प्रपोजल कितने रखा कितने अनुमोदन दिया उनका नाम वगैरह फर्स्ट टाइम पे जब हम नेम के एप्लीकेशन डालते हैं उसमें आप 500 करो 1000 करो 2000 करो जो कि आपके ऊपर ऑल द रिस्पॉन्सिबिलिटी इसके ऊपर आपकी मीटिंग में इसका लिस्ट बनाया जाता है आइटम नंबर 1 2 3 बाद में लास्ट में स्पीकर प्रमोटर हर एक पेज पे नेम के एप्लीकेशन साइन करेगा उसके बाद आपका एप्लीकेशन सर्टिफिकेट किया जाएगा बाय द कंपनी होगी डेपोजिटर में और कोड 50 से कोड 30 से 7 में उसके बाद डिपार्टमेंट परफॉर्मेंस के अकाउंट करके आते हैं ठीक है स्पीकर प्रमोटर अब स्पीकर प्रमोटर फर्स्ट वर्ड जनरल बॉडी में अभी फर्स्ट जनरल बॉडी आप लेते हैं उसका मिनट बनाते हो वो नेक्स्ट मीटिंग वो रेशन होने के बाद में आपके हाथ में सर्टिफिकेट मिलने के बाद में आप नहीं कर सकते वही फर्स्ट मीटिंग में किसी को करना पड़ता है कमेटी मीटिंग में फर्स्ट मीटिंग जो लेते हैं वगैरह उसमें उसमें फॉर्मेट नहीं रहता है, फॉर्म रहता है। उसमें फर्स्ट मीटिंग में आप क्या करते थे, एक सोसाइटी का नाम आप फाइनल करते हैं। उसमें एक फर्स्ट नाम, एक नाम, दो नाम, तीन नाम, चार, जो भी है हर एक का जो आता है उसके हिसाब से उसमें आपको बाकी के सब आपके शेयर कैपिटल, एंट्रेंस, बाकी के जो है रेजोल्यूशन पास करना पड़ेगा। पहला जो मीटिंग रहता है जनरल बॉडी मीटिंग रहता है, फर्स्ट मीटिंग जो है, फर्स्ट जनरल बॉडी मीटिंग में आपको रिजर्वेशन पास करना पड़ेगा। तो बाकी के बाद हाथों से मेंबर वगैरह है तो पूरा रजिस्टर होने के बाद बराबर पहला इकट्ठा आते हुए मीटिंग में लेते हैं, तो मीटिंग में वो पास करना पड़ता है, उसमें रिजर्वेशन होता है फॉर्मेट। तो पहला ही मीटिंग लेते हैं ना सब मेंबर का, क्योंकि आप सब इकट्ठा होकर मीटिंग लेते हैं और इकट्ठा होकर आप सोसाइटी के नाम वगैरह फाइनलाइज करते हैं ना, कौन सा नाम देने का, कौन सा नहीं, कौन सा ऑप्शन इसमें फॉर्मेलिटी रहता है, तो वो कंपलसरी दिया है और दिया है, चार नाम देना होगा अल्टरनेट।
Your question will be. The body is the general body. General body means the flat person. When it's member of the society. If the society is not formed, they don't become a member of the society, right? Body. See, when you are going for society formation, the committee comes in picture after formation of society. Once you form a society, then the managing committee is the elected. The provisional managing committee is initial stage, and then the proper managing committee. So, committee meeting means after formation of society. Right now, you are on formation of society. So, you go to general body meeting. Now, how will we call it general body meeting? See, to avoid that groups of people form society. आज यहाँ पे 100 members है society के, suppose there are 100 flats. Means anytime आपको form a society, other form a society. To avoid this, what the department has said that out of 100 flats, maximum members shall come together form their entity. So how do you call them? Give them a notice. Maximum members are invited in that particular meeting. It means maximum members are informed that one proposal is going to be put up. So that the second proposal is coming up, this is saying that a proposal already cannot here. So this is publication. So that is called as the first general body meeting. And after that, once you form a proper society is formed, then you have your proper elected general body meeting. Official general body meeting. This is not a proper official meeting. Right? Once you form your society, then you have your first general body meeting. In that meeting, after that, you have your provisional committee and all this. So this meeting which we are talking about is general body meeting, not a committee meeting. In this condominium, you are having a committee, but that committee you cannot combine with the commercial society committee. Both are the separate entities. Okay, so that committee cannot work here as one of the committee. A new fresh election will be taking place. So here the meeting was a general body meeting, not a committee meeting. Clear? Clear, sir?
So next is to take up by advocate Kiran.
Now the topic is conveyance or refund. The hottest topic today. You are no the content who appearing to the hearing and arguing the matter. Now, what do you mean by conveyance? Conveyance is important status that can be
Which number of knots that all the PPTs, the picture will be given to all the participants. Some of the PPT are the graph is the extent.
So since we are talking about an entity, so being an entity, the conveyance is your the land and the building, not a particular flat. So conveyance is transfer of title of land and building from the promoters to the particular society. Now, once you form a society, you have to go through the bylaws. The objective of which the society is formed, that is to get a conveyance in favor of the society. अगर आप कोई bylaws निकाल के देखोगे society का, तो first objective will be to obtain the conveyance. Get the conveyance, you are not fulfilled the objective for which you have formed a legal entity. So, transfer the title of land and building. Objective of forming an entity. So, become a legal owner. I don't know the land owner himself. So that is considered there. After the developer comes to picture, he develops a building. So there are two separate persons. One is the land developer. Landowner title. Developer has a structure in his title. What are you people purchasing just a flat? So you have a title of a particular flat. Now, if suppose an incident occurs, so at that time, if the building collapses, the flat person is not left with anything. Again, they have to invest some money, approach the developer to install the building and then get the flat back. So that is the reason the objective of society formation is to become the legal title of the land and the building which you are residing and you have invested a hard-earned money. So once you purchase a flat, you have to fulfill the objective of the society to get a title transfer. To get a transfer title in the favor of a society. Now, the title are two titles. It may be freehold or it may be leasehold property. If it is property leased by the landowner to the developer or something like that, in that case, you can lease a property. If it is freehold, you can have freehold property. Before we get a lease, but if it is property, property. If you owner, once you form a society, firstly, what is the MOPA provision say? If you go to the RERA, if the RERA says to obtain the conveyance from the promoter within a 3 months from the date of the society is formed. That is not done. The RERA also speaks that if the conveyance is not given, you have to go under the MOPA Act and obtain the conveyance. So RERA does not have any provision that you can approach the RERA and get the conveyance. You have to approach the CPR. Even RERA, okay. So you become the legal owner. So you have to.
Now, firstly, the objective is you become the legal owner of the property to make the entries in the government record. First is the land and the building is conveyed in your particular name. The same is done in the mutation entries. Even the after all final motive to become the owner of property is to get the entry done in the property card, to get the mutation entry recorded in the property card or else 712 extract. So that is one of the objective, to have a free and marketable title. Once you obtain the conveyance, you have a free and marketable title of the property. Then transfer of ownership rights over the land. The land and the building is been conveyed in favor of a society. All commercial benefits come to the society. What do you mean by the commercial benefits? It means if any future FSI is there, so that can be utilized by the society. If you have any balance FSI, that you can give to the other developer or someone in the form of a TDR. So that is also a commercial benefit. Apart from that, the terrace, something like antenna if you want to do. So all those things you do not require the permission of the developer. That can be done by yourself. And you can earn the commercial benefits. Appreciation of property, the rate of the property increases after the conveyance has been done. Then loan can be raised by mortgage. Why is this said? Because in future when you want to go for redevelopment and the conveyance is not done, it is impossible. Then when the conveyance is done and you want to go for redevelopment or self-redevelopment basically, so at that time you can mortgage your property, the land, and then you can obtain the loan against it and have a self-redevelopment done. Balance FSI can be retained. Whatever is the increased FSI after you get the conveyance, all the increased FSI will be utilized with the said society. permission for redevelopment is possible. Now, conveyance is of land and building. As I've told you, land may be freehold land or it may be leasehold land. If it is a freehold land, if the property card basically it shows holder, it means it is a freehold land. So in that case, you get a ownership rights after you obtain the conveyance. If it shows as a lessee, if it is not a freehold land, then you may get a lease of that particular property. Lease may be for the perpetual lease. Then conveyance of the building. If in case there is a lease for the particular land, there are two types of conveyance then. You can obtain lease for the land and conveyance for the building. And if it is freehold, in one single document, you can obtain conveyance for land as well as the building. There are two separate things. If it is a freehold land, in one single deed of conveyance, you can obtain the land as well as the building. But if it is a leasehold land, so in that case, you need to get the deed of assignment for the land and freehold for the building. Now, methods and ways to get the conveyance. Basically, RERA provision says that you need to go to the DDR under the MOFA to obtain the deemed conveyance. What does the MOFA provision says? Within a period of 4 months from the date your society is formed, the promoter has to give you the conveyance. Who are the promoters, the landowners and the developers? They need to give you a conveyance. But basically it is seen in 90% of cases, they don't give it with some vested interest. So what can you people exercise is you can approach the developer and get the conveyance. That is one of the regular conveyance we say, a normal conveyance where the developer and the landowners are ready to give you the conveyance. Second, you can get a conveyance is through the court cases where you can approach before the cooperative court, a city civil court and the consumer court. Third is deemed conveyance. This amendment has come up in the year 2008. Now, conveyance by builder. This is what I'm talking about, the regular conveyance. What does this mean? That the developer has constructed a building and now the developer has a power of attorney, a registered power of attorney in his favor to assign the title in your favor. So in that case, the developer is ready to give you the conveyance. In that case, you need to draft a proper deed of conveyance with a proper area which you are entitled for, give it to the developer for vetting, and he will be registering your document. So this is what it says. Conveyance by builder is to approach the builder, collect all documents of land and building and members. What do you mean by documents of land? It means this property card, 712 extracts, all these are the land documents. We say the CTS plan, which shows where your building is located on which CTS number. Then comes a building document. Building document means your IOD, TC, OC, your building plans basically, the layout plans, where it is a layout development. Then the members. What documents are you going to collect from the members are the agreements of all the members. Those are duty, right? Yeah. So agreements, at that time you need to collect to see whether all the stamp duties have been paid. Till the time the stamp duty is not paid on all the agreements, the deed of conveyance won't get registered. So if at the time of registration of society you don't pay the stamp duty, after all you are required to pay at the time of conveyance, at the time of registration of conveyance deed. If at that time anyhow you have to pay the stamp duty, whether with penalty or without penalty, whatever it is. Now, prepare and approach the conveyance deed, adjudication and pay stamp duty. At that time, you have to adjudicate your document, pay the deficit stamp duty on each and every flat and all the documents, and then register the conveyance deed by authorizing sub-register office of all the parties. Obtain index to an original conveyance deed. Once you register your deed of conveyance, that will be registered by the developer if he has a registered power of attorney from the landowners and by the society. So that becomes a formal conveyance deed document, a registered document. Then obtain index to an original conveyance deed. You need to obtain the certified copies. Then apply for city survey office for name change. That is a final motive. Obtaining a conveyance means it doesn't mean that you just get an order of deed of conveyance or you just get the registered deed of conveyance. Your final motive is when you get your name change done in the property card. That is the day when you can say that you have obtained your conveyance in favor of your society. So this is a regular way in which the developer is cooperating, and through that way you can obtain the conveyance. Apply for city survey office and get the property card change in name of the society. Now, under section of 11 of MOFA, section 11 of MOFA says within a period of 4 months, you are required to convey the property. Now, you can, if it is not done, what are the ways you can go? You can either go through court cases, get a legal remedies, that is under the Specific Relief Act before the City Civil Court. You can approach before the consumer court since you are the consumers who have purchased the flat, or else you can go under the criminal court under section 13 of MOFA. So these are the things, or else before the cooperative court. So if you go before the litigation courts, proper litigation courts, you are going to spend n number of years for getting convinced. And after you get an order, suppose you get an order, the court again you have to get the decree for execution. Meanwhile, the landowner, other societies, or the developers are going to file appeal for that. So that matter is going to drag on drag. Then when you go for execution, again they may file an appeal for that. So to reach to the final motive, it may take n number of years. So for that reason, the new amendment has come up in the year 2008, where a separate deemed conveyance has been come in picture. Means you are deemed to become a member within a period of 4 months if it is not conveyed to you. But formal, orally, you cannot become a deemed member. You need something in return. So that authority is given to the district deputy registrar under section 11 of MOFA. What does it say? A quasi-judicial authority has been set up. He has been given powers under section 5A of MOFA, under which he can take up the deemed conveyance applications, decide and give the conveyance certificate to the society. But here, he has a dual role. When you go to the court, you get a decree and then you have to apply for execution. Here, the DDR has a right to firstly pass an order and secondly to implement the order. It means first he is going to pass an order for you and he himself is going to sign on the deed of conveyance document. It means he is going to step in the shoes of a developer and the landowner and sign that particular document. Okay? So that is going to be easy for all the societies. So through the competent authority as per section MOFA Amendment 2008 District Deputy Registrar. Now, amendment to rules were made to implement the functioning competent authority and MOFA Amendment 2010. In the year 2008, the Act was implemented, Section 11 was modified, and then later Rule 9 was modified. Now, deemed conveyance by competent authority. MOFA was amended on 25th of February 2008, where I have said you Section 11 was amended and the deemed conveyance concept was brought into the picture. District Deputy Registrar, the competent authority is notified. Amendment to the rules were made to implement the functioning of competent authority and MOFA amendment rules. Now, when you go under section 13 for Criminal Act, it is said that you can put the developers behind the bar. Now you can see that many of the cases developers are put behind the bars under section 13 of MOFA. What does that say? If the developer has not fulfilled his obligation, you can take a criminal action against him. What action has been taken? He can be put behind the bar for 3 years or with penalty. But that won't serve your motive. Just punishing the developer is not going to serve your motive. That does not say that he will be giving you conveyance. That just says he will be penalized or he will be punished. So that is the reason we also don't go for section 13. But there were many articles which says that you can put the developer behind the bar. Now it is upon the society what they want to proceed with. Now deemed conveyance is as good as conveyance. There are many misunderstanding that there is a difference between conveyance and deemed conveyance. So we should avoid deemed conveyance and we should go for conveyance. As basically a client says, कि अरे नहीं हमें conveyance के लिए जाना है, हमें deemed conveyance के लिए नहीं जाना है. It is both the same thing. In conveyance, the developer is and the landowners are going to sign and execute your deed of conveyance document. In deemed conveyance, the developer is going, the competent authority is going to step into the shoes of the landowner and the developer and going to execute the document. Rest everything is same. What is going to change is only the time frame is going to change, where you are going to approach the DDR, proceedings are going to taken place before him, and the time frame will increase to get an order. Rest, once you get that order, after that everything is same. The draft will be done, then you need to finalize the draft, you need to go for ADJ, everything remains the same. Only one thing will be increasing, that is you make an application before DDR, and the hearings will be taking place and order will be passed. Now, the deemed conveyance is treated as good as conveyance. It's a legal fiction, but now actually to be conveyed through competent authority. Deemed conveyance is conveyed to the competent authority. Documents required for conveyance. Basically, if someone is trying to go for conveyance, firstly, they have to procure all the necessary documents. Without the sufficient documents, you cannot decide what area are you going to get, which is particular your building. Suppose if you are not known that which is your building and wrongly you have taken some other building or some other area, again, after some years, you have to start with zero. So that is the reason before proceeding with the conveyance, you need to find out the right documents. Now, what are the documents? For filing an application, you need to prepare form number 7 for deemed conveyance, along with court fee of rupees 2,000. Then certified documents of land. You need to procure the 712 extracts. You are required to procure the city survey plan. Then the CTS plan, the property card. These are the land documents. These are required to be procured. Then you are required to procure certified copies of building documents. Building documents, under the provisions of MOFA, it says that the landowners and the developers are required to convey you with the documents once the handover process. They are required to give you all the documents. Basically, it is seen that many of the society does not have the development agreement. They don't have the building document. They don't have the layout plans since it is not given by the developer. In this case, what you can do is you can apply for an RTI, and through RTI, you can get the certified copies of all the building documents of your particular building. So these things you need to collect first, and then you need to proceed with a deemed conveyance application. Then flats agreements duly stamped and registered. That is one of the things you need to check whether all the agreements have been registered. It is not registered. Application identity society registration certificate is required to know which is your society exactly. Others relied upon by the applicant. Area certificate by an architect. This is one of the things. Before you put up an application for deemed conveyance before the district deputy registrar, you need to be very sure with the area what you are asking for under the conveyance. Because making an application won't take you the time. But if you get a wrong area or wait, you are going to face problems at the time of redevelopment. So first be very sure with what area are you getting for. So for that reason, you need to obtain architect certificate, take opinions from the separate architects, or get the physical survey done if required. Then survey number and CTS number should be known, which you are asking for is an accurate CTS number. Many of the time it is seen practically that the society gets a conveyance, the order has been issued, but when they pay the stamp duty, they get the deed of conveyance registered. But when they go for name change in the property card, it is known that that CTS number doesn't belong to their building exactly. The land on which the building is constructed, that CTS number is not the particular land which they have been conveyed with. So again, they have to start with zero. So again, they have to spend around 10 years for that. So before that, you need to be which your land is constructed, which CTS number are you demanding for conveyance? And then you can ask for that particular order. Search report of the advocate to be given is not compulsory, but you need to see. You need to get a title search done from the title search surveyors and get if there is some title being created in respect of that particular land. Now again, the same residents send builder to jail, but you are not going to get anything from that. Now, what if you don't obtain the conveyance? There was a case in Borivali, in one of the society, where the building got collapsed. It was, I guess, 30 years old building. It got collapsed. After it got collapsed, the residents were left with nothing because, again, they have to approach the new developer and they did not have money and they did not get that particular flats again. So for that reason, it is said that first you need to secure your property, obtain the conveyance in your favor, and then go for redevelopment. Once you have the land title in your name, and if the building collapses later on, so the society themselves can generate the funds and then, or they can mortgage that land and they can redevelop the building. So this is one of the case which was happened. Now, documents required for conveyance. Once again, society registration certificate, stamp duty and registration paid, proof of each individual, agreement for sale by the promoter. Now, once you're applying for conveyance or any of them, you should first know what is the flow of title of the particular land. Means from whom the title have been passed. Many of the times you are not given the development agreement. So how do you come to know that who is a landowner, then who becomes a developer, how does the title has been transferred to him? All this information you will be getting in the agreement which is executed by the developer with the flat purchase, the first agreement. When you purchase a flat for the first time from the developer, that developer executes an agreement under section 4 of MOFA. That agreement has a detailed flow of title. That flow of title will show you how the title has been passed from separate landowners or developers or separate parties, and how does finally a building has been constructed. So that shows you the n number of chain of agreements. So then you can cross check whether do you have that particular agreement. If no, you can put up an RTI. If you get through RTI, well and good. If you're not getting, even in that case, deemed conveyance can be done without this document. Without the previous chain of title documents, you can get the deemed conveyance certificate. Then commencement certificate, CCOC is required, approved building plans are required. These all things you need to obtain. 712 extracts from Tehsildar. Form number 6 are the mutation entries, title search report, index 2 from the sub-register of assurance, once it is registered. Property card, NA orders, development agreement. So these are the documents which are basically required for conveyance, whether it is conveyance, whether it is a deemed conveyance. Now, what do you mean by promoter? Promoter means the one who constructs or causes to be constructed. Who constructs means very sure the developer. Causes to be constructed means the landowner, because the landowner was willing to construct, so he has given the development right to someone. So landowner, the developers are considered the promoter under the provisions of MOFA. The promoters have a statutory duty to convey the title in favor of the society. Now, the amendment was done under the provisions of MOFA in 2008, and the district deputy registrar has come in picture, who has been vested with powers to give you the conveyance. Now, once you file an application, first what we suggest to the societies are usually practical experiences. First, try whether you can get a conveyance from your landowner or your developer. If no, or if they are ready, suppose in many of the cases we have seen that the developer says, yes, we are ready to give you the conveyance once a legal notice goes to them. If they are ready, then we have to first check what area are they willing to give it to you, whether that area is what you actually entitled for, or whether you have to compromise for something, whether for FSI or for the construction or something. If you don't have to compromise for anything, or if the area which you are entitled for, he is giving that area, you can very well go for the registration of deed of conveyance as a regular conveyance. But if not, if you have to compromise for your area or any other thing, you can go for a deemed conveyance. After filing a deemed conveyance application, the district deputy registrar is vested with the powers to look after the application, scrutinize, conduct hearing, and pass an order. That time frame from the date of making an application till the order is 6 months. It means the registrar has to pass an order within a period of 6 months. You make an application. Now you can compare how much time will be going for litigation if you go before a city civil court, if you go before a consumer court, or before a cooperative court, and how much time is going to take if you approach before the district deputy registrar. So no one has a time to spend 20 or 10 years before the court, and that is the reason now everyone approaches before the district deputy registrar for deemed conveyance. Now, once the application has been filed, they are going to check all your documents, whether it is correct, it is not correct, and then the hearing notices will be issued. Then hearings will be taking place. Now, what has to be made sure is, while you go for deemed conveyance, who are the one to whom you are making a party to the application? Many of the time, the order is also been, we receive the order also, but later on, the same is challenged before Honorable High Court. For what reason? The reason is the proper owners are not made as a party to the application. So you always need to check that who are the ones who has a title in that particular property. That can be seen to the property cards, to the previous agreements. So all those who are directly or indirectly related to that particular property are required to be brought in picture in that particular application. If no one appears, you will be getting an ex parte order, but you need to bring them on record. If it is not brought on record, the same can be challenged before the High Court for misjoinder of parties. Or else your application before the DDR itself may get rejected for misjoinder of parties. Now, then he is going to conduct the hearings, appearances is going to take place, in which you have a right opportunity to present yourself, the developer, the landowners, the legal heirs of the landowners may appear, the partners of developers may appear, they may get a right to present their stand, whatever it is. After hearing both the parties, the DDR is going to close the file, and then he's going to issue an order in favor of a society. That will be called as a deemed conveyance certificate, which says that the society is entitled for this much land area, whether it is freehold or whether it is leasehold, along with that particular building. So that is what opponents have filed the written reply on the next date. Cross-examination will not take place over here. If you go before the proper litigation court, that is city civil court or other court, the cross-examination and all those things takes place and the time frame increases. Here, no cross-examinations will take place. You both have a right to file written reply as well as orally argue your matter. After you have done with oral argument, no cross-examinations are going to take place. On receipt of reply, the competent authority may hear oral arguments of the parties and close the proceedings. Within a period of 6 months after that inquiry, he is going to pass an order for that. Now, that order will be a speaking order and certificate that the applicant case is a fit case for getting unilateral deemed conveyance issued. So it is a speaking order which has a complete detail with respect to facts which you have produced, the details which they have produced the other side, and what is their observation. So it is called a speaking order. Now, next is registration of deed of conveyance. Now, once you get a certificate area, you need to go for implementation. Before that, you have to first clear your stamp duty. Before registration, all the stamp duty should be clear for all the particular flats. For that, the societies need to collect the agreement chain of agreement of all the members of the societies. Those agreements are required to be submitted before the collector of stamp. They are going to issue challan for that, whatever the deficit stamp duty. At that time, each and every flat, whatever is the deficit stamp duty, that is going to be notified to you. You are required to collect that stamp duty from all the members and pay to the collector of stamp and then proceed for registration. If suppose in that there are cases where the members don't pay the deficit stamp duty, till the time stamp duty is not paid, you cannot proceed for registration. Societies do not want to stop their processes. What do they do at that time? Practically, they utilize the society funds and they pay the deficit stamp duty, and later on they recover those amount from the members through recovery of dues. So that is one of the way to not stop your deemed conveyance process. So you need to get adjudication. The stamp duty has to be paid. Once you pay the stamp duty, within a period of next 3 to 4 months, your deemed conveyance, deed of conveyance will get registered. In this case, the DDR itself has an implementation right. He will be executing the landowners and the developers. You need to lodge for registered sub-registrar. Now, see, this is a conveyance deed basically. And this is a place in where the district deputy registrar executes the document on behalf of the landowners and the developers. So in this way, the deed of conveyance is going to be registered once the stamp duty is paid. Suppose there are cases where there are new flats, new construction. So in that case, almost all the stamp duties have been paid. So suppose if all the stamp duties are paid, in that case, the deed of conveyance will be registered only with a stamp duty of minimum 100 rupees against each flat. The number of flats you have, each member has to pay 100 rupees. That's it. With that, your deed of conveyance will be getting registered. Now, once you finish registration of your deed of conveyance, the next is to get it entered in the property card. So that is the next procedure. So you need to get the mutation entry recorded in the property card, for which you need to apply before the city survey office, and in case of 7-12 extract before the Tehsildar office. You need to clear their objections and then get the entry recorded in the property card. So the day the entry is recorded in the property card, it says that your deemed conveyance or your regular conveyance is completely done. Now, during this complete process, from after formation of society till getting the name change done in the property card, what are the various acts and the provisions which comes in picture, which you must be known aware of? That is Registration Act 1908 for registration of conveyance deed, Bombay Stamp Act for stamp duty verification calculation, MCS Act under which society is registered, Income Tax Act to verify the tax liability of vendor, Maharashtra Ownership of Flats Act 1963 under which the flats have been purchased. Acts and rules applicable are ULC. Not practically, but usually you should be known aware to it. Not required. Practically it is not required. But these are the major acts which are required for conveyance. Now, Criminal Procedure Code, Civil Procedure Code, Consumer Protection Act, DMC, Development Control Regulation 1991, Land Revenue Code, then bylaws of their society. So these are the things which you should be known for while proceeding for deemed conveyance or regular conveyance. Now, departments to be visited. Now, when we tell about the conveyance, regular conveyance has to be through 3 departments. Deed of conveyance is done by the developer. So what will be the next government department? That will be the collector of stamp. Then next is the sub-registrar who is going to register your document, and the city survey officer. So in case of regular conveyance, these are 3 government offices. But when you talk about the deemed conveyance, in that case, there are 4 separate government authorities. The one is DDR, the district deputy registrar, before whom you are getting deemed conveyance certificate. Then comes your collector of stamp, before whom you are going to pay your stamp duty. Then comes your sub-registrar of assurance, before whom you are going to register your deed of conveyance, and then comes the city survey office, who is going to make the mutation entry. So these are the 4 government authorities who are required to function for giving a proper conveyance to you. And many more departments on case-to-case basis. Suppose for NA you are required, or ULC, whatever. Now, earlier, before 2007, 2008, the conveyance, if the building does not have an occupation certificate, conveyance was not given. That was one of the obstacles. Even now, that obstacle has gone. So even if the society does not have an OC, because it is the developer's duty to obtain the occupation certificate for the building. If he fails to comply with his duty and he fails to get the occupation certificate, even then you can proceed with the deemed conveyance and get it registered. So this is one of the new thing to know, that even if you do not have an occupation certificate, you need to give an undertaking to the DDR that don't have the OC, and in future you are going to apply for the OC, but that won't stop your conveyance. the society has any other litigation matters before any other cooperative court, any other court, even then you can go for deemed conveyance. But one thing is, if you have made an application for deemed conveyance before consumer court, sorry, if you have made a deemed conveyance application before the consumer court or before the cooperative court, and simultaneously at the same time you cannot approach the DDR, then he is not going to pass your order. Or if suppose there is a stay on that particular property before the Honorable High Court, or the interim order has been issued, at that time your deemed conveyance order will be rejected or it will be stopped. Rest, you can obtain the conveyance without any obstacles. Secondly, even if there is balance FSI on the land, many other times when we go for an argument, what argument the developer present is, there's a balance FSI on the land, so conveyance cannot be given. Because if the conveyance is done, that FSI goes to the society. So even if there is a balance FSI on the particular layout plot of land, the conveyance will be given. The conveyance cannot be stopped. So this was basically regarding the deemed conveyance. Now we can take up the questions if anyone has. कोर्ट में किस चीज का केस, कन्वेंस को लेके ही केस? कन्वेंस को लेके आप एक चीज को लेके आप दो जगह नहीं जा सकते. Either you approach before the DDR or either you approach before the litigation court, as I've said you. But अगर कोई और मैटर को लेके आपका चल रहा है, जैसे आपने डेवलपर के अगेंस्ट कंप्लेंट फाइल किया है फॉर सर्टेन सर्विसेज हैव बीन नॉट प्रोवाइडेड टू यू, तो दैट एंड कन्वेंस आर टू सेपरेट मैटर्स. तो उस केस में आप कन्वेंस के लिए जा सकते हो. डीडीआर में आप कन्वेंस के लिए फाइल करो और बाकी चीजों के लिए आप सिटी सिविल कोर्ट में फाइल करो और कंज्यूमर कोर्ट में फाइल करो. दैट कैन बी डन, बट with respect to one single prayer, you cannot approach before two competent authorities or before two separate courts. Sorry? No, देखिए, अगर जब तक आपके उस पर्टिकुलर लैंड पे कोई स्टे नहीं है, हाई कोर्ट का या सुप्रीम कोर्ट का जब तक कोई स्टे नहीं आता है, तब तक आपको डीम कन्वेंस के लिए कोई रोक नहीं सकता. आप आगे जा सकते हैं. ऑब्स्टेकल्स आएंगे, हियरिंग में आर्ग्यूमेंट्स होते हैं, उसमें वो लोग कुछ डॉक्यूमेंट प्रोड्यूस करते हैं, काफी नई चीजें पता चलती है. कभी कभी राइट ऑफ वे अग्रीमेंट प्रोड्यूस किया जाता है, आपको पता भी नहीं चल रहा कि आपके लैंड पर राइट ऑफ वे क्रिएट किया गया है, तो वो लोग उस टाइम पे बताते हैं कि ये राइट ऑफ वे हमने ऑलरेडी क्रिएट कर दिया है. बट दैट इज नॉट गोइंग टू स्टॉप योर कन्वेंस, वो आपको मिल जाएगा. सो अगर आपको डेवलपर के थ्रू कन्वेंस नहीं मिल रहा है, आप डीडीआर के पास जाके सर्टिफिकेट ले सकते हो. और जब सॉरी अपील में गया है मैटर, वो किस चीज का मैटर है वो देखना पड़ेगा सर. कन्वेंस का ही है तो फिर डीडीआर के पास आप जा नहीं सकते, बिकॉज ऑलरेडी आपका एक जगह मैटर चल रहा है. इसके लिए you need to first check whether that is sanctioned by MCGM or not. अगर illegal construction होता है suppose without any permission or sanction from MCGM, वो आपके कन्वेंस को चैलेंजिंग कर देता है. बिकॉज अगर आपको ऑर्डर मिल भी गया सपोज, तो दैट में भी चैलेंज बिफोर द ऑनरेबल हाई कोर्ट एंड दैट में स्टैंड. बट अगर आपका कंस्ट्रक्शन जो है वो लीगल है, सैंक्शन लेके किया बट ओसी नहीं आया, सपोज एक बार ओसी आ गया है, एडिशनल कंस्ट्रक्शन किया गया है सपोज, बट वो एडिशनल कंस्ट्रक्शन का ओसी नहीं लिया है, बट प्लान्स हैव बीन सैंक्शन कि वी आर ट्राइंग टू पुट अप दिस मच स्ट्रक्चर्स, परमिशन लिया है, सो दैट इज नॉट गोइंग टू स्टॉप यू फ्रॉम गेटिंग द कन्वेंस.
मैम आई हैव क्वेरी.
One month. See, what does RERA says? The day of society is formed, within a period of 3 months, conveyance should be given by the promoter. This is what the RERA says. But if it is not done, do you file a complaint before RERA? No, because RERA don't have that provision. What does RERA say? If they don't give you the conveyance, you approach before the competent authority under the provisions of MOFA. So even the RERA says you to go before the MOFA, because the district deputy registrar is the only authority, the quasi-judicial authority who can issue the deemed conveyance certificate. The RERA does not have a right to issue deemed conveyance certificate. What does RERA says? That within a period of 3 months from the date 51% flats are sold, you need to form a, you need to say, or the date you obtain your OC or the 51% flats are sold, you need to form a society. What does MOFA say? That within a period of 51% flats are sold, you need to form a society. It is same. But again, to form a society, you need to approach before the registrar, not before RERA. RERA doesn't have a jurisdiction to form a society and issue you a certificate. If you go through the RERA provision, that also refer you to MCS Act. Because under section 9 of MCS Act, the registrar has an authority to issue you a certificate of registration. That certificate of registration cannot be issued by the RERA authority. So anyways, you need to approach before the deputy registrar for society for registration of certificate. But if it is in non-cooperation, before the district deputy registrar.
Ma'am, I have a query. Apart from cooperative society, if we form partnership or company, whether
Yes.
dim conveyance provisions are
Yes, it
applicable
can
for
be. See, what does it say that under section 11, it says that conveyance has to be given either to the cooperative society or to any other legal entity. That may be a company or association, whatever you form. They have to give you a conveyance. So if you have formed a company, you can also make an application in the name of a company, LLP, whatever it is. But basically, it is seen in Mumbai that 90% of conveyance are operated in the name of a society. But no doubt that you won't get a conveyance in name of a company. You can approach for conveyance in name of a company also. Same in the DDR, the district deputy registrar. Yes, to issue your deemed conveyance, that is the only authority.
In case of a building, in case of a land where there are two buildings,
So
one is,
please one by one.
yeah, over here.
Yeah.
In case of a land where there are two buildings, one is completed and OC is received, the other is still under construction. And we need to give conveyance within 3 months as per RERA Act. So how do we proceed?
See, even if one building is constructed, other building is not yet completed, or if they have not received OC, that won't stop your conveyance till the time the area which you are asking for is only with respect to your building. If that building is incomplete और आप उनका एरिया मांगोगे तो आपका एप्लीकेशन रिजेक्ट हो जाएगा. बट आज आपकी बिल्डिंग में जो FSI कंज्यूम हुआ है, whenever we go for a layout conveyance, अगर आपकी बिल्डिंग लेआउट में है, where there are more than one building, that is called as a layout development. So whenever it is a layout development, if you are going for a conveyance with respect to your particular building and the area in proportion to your building, you can get an order. That is not going to stop you from obtaining that particular order. See, if you go to the GR of 22nd June 2018, what does that say? कि अगर आपका layout development है, in that case, you should be getting a conveyance for the plinth area and the apparent area. And the other common area should be conveyed to the federation. So that is one of the things. Second, we have a Supreme Court and High Court judgment. Saraswati apartment, that is one of the landmark judgment. What does that say? That if it is a layout development, and in case of a layout development, if the developer has constructed building without physically demarcation of the land, if the land is not physically demarcated, that is his mistake, that he has made a layout development. So that cannot stop you from getting conveyance. So in that case, whatever you have constructed your building is completed, you need to ask for the conveyance for the area in proportion to your building.
Builder is bound to do that.
Sorry, builder is?
So builder is bound to grant conveyance for the building that is already completed.
Yes. If you are asking for the right proportioned area for your building, that is not going to stop you from getting deemed conveyance certificate. That may also be challenged before the High Court, but if the area you're claiming is correct, so your stand will be good. See, that is a long way to go. Actually, you need to take architect's opinion also. See, either you go for a plinth area, you need to check firstly what is the interest of your client. What are the situation? I cannot say one particular thing कि आपको proportionate ही जाना है, आपको plinth ही जाना है. Depends upon case to case basis. But basically, we go as per the proportionate. If there is only one building in one layout, if there is a land of around 500 square meters, if there is only one building on that land, the complete 500 square meters will be conveyed to them, irrespective of the built-up area. If it is constructed more. But if a land is, if there is a layout development, if there are 2 or 3 buildings been constructed in a land, so one GR says convey the plinth area. The one of the landmark judgment says convey the proportional entitlement. Proportional entitlement with respect to what the FSI utilized by your building. जो हम बांधकाम बोलते हैं कि आपके बिल्डिंग का बांधकाम कितना हुआ है, वो आपको किस पे पता चलेगा? आपका बिल्डिंग प्लान से. When you go to the performance statement, that shows the total area of the plot, that shows the FSI that was permissible, the FSI which is used by your building. So whatever FSI is used by your building, उसके proportion में अगर आप area claim करोगे, so you are on the right track. Plinth means only the plinth on which your building is been constructed. So many of the times if you go for plinth conveyance, that creates problem at the time of redevelopment. At the time of redevelopment, it is only the plinth which is conveyed to you and the apparent area. Then again, you have to take NOC of the other societies for redevelopment. But when you are taking conveyance for the proportionate area, only for the proportionate area, at that time you are independent. You don't have required NOC of any other societies for redevelopment. So that is the reason, again, I'm telling it depend upon case to case basis that how area you are claiming for. Also, take an opinion of an architect for that. Who used the member used? See, once you see, firstly, the conveyance which you get, the area which has been considered, that what area you're entitled for is as per the OC plan if you have an OC. If you don't have the OC, the last plan which has been sanctioned. OC says that your building is completely proper to occupy, and that is the last plan. After that, the members, the owners cannot make any structural changes in the structure. If it is done, they need to take a proper permission of the BMC, need to get a plan sanctioned, and only then further construction can be done. Any member cannot extend because of the balance FSI, they cannot utilize that balance FSI. Balance FSI always goes to the society, not to any particular member. Okay? So if it is done illegally, so very correct, that may stop your conveyance because it is illegal construction without the permission of MCGM. But if it is done with the permission of MCGM, then you can smoothly run. In your case, it is done by the member you're telling, right? It is done by the member. So it is illegal construction without the permission of MCGM. So that may create an obstacle for conveyance. So first you need to regularize your construction through BMC. Once it is regularized, then for the sanction plan or what sanction certificate, you can apply for the conveyance.
Ma'am, in
MIDC property, you get a lease. That is not a freehold land. So for redevelopment, you need the permission of the particular competent authority. MIDC itself. See, SIDCO is a separate authority, MAHADA is a separate authority. So all these are separate authorities. So if your plans are sanctioned by them, you need to approach them and then you need to get a lease from them, not before the DDR.
ma'am,
Only when the land is freehold land, in that case, the DDR comes in picture, but not in case of MAHADA land and all those things.
when the building is under construction and the flats are sold more than 51%, and after that, the members form the society. During the under construction project, can the society go for a conveyance or it has to be a
Society
complete?
can go for a conveyance in under construction stage because the provision of MOPA says that within a period of 4 months from the date you form a society, you need to get a conveyance. But अगर आपका construction ही complete नहीं हुआ है, तो आपका total built up area भी correct नहीं आएगा. So उसमें आप area lose करोगे. That is one of the thing. Second thing is, at that time you will be getting a plinth conveyance. Get occupation certificate and then proceed for the conveyance. But अगर आपकी building पूरी तरह complete हो गई है, आपने रहना start कर दिया है, construction complete है, then अगर आपको occupation certificate नहीं आया है, like in many other societies still now they do not get occupation certificate, then you are not required to wait, then you can proceed for conveyance. Thank you so much.
It was a marathon lecture. Not wasting much time, I request CA Prasad to give the vote of thanks to all the three speakers.
would like to thank esteemed guests who took their valuable time to join us today. I just got to know that it was first speech of Vikram sir, and it requires immense courage to give speech in front of such an intelligent audience. Big round of applause from him. Uh, Thank you, Santosh sir, who made it simple to understand the complicated provisions in RERA Act. Also, thanking to Kiran ma'am, who taught us such an important and valuable topic conveyance in very easier manner. Thank you all for your insights and valuable. We will have a quick 20 minutes break, and we will gather here after 20 minutes to hear some valuable words from Karthik sir. Thank you.
Corporates in addition to the other Indian corporate and HNI clients in area of FEMA, DTA and tax compliances, including present representation before various government authorities and tribunals. He has performed professional assignments, audits, opinions, meetings, negotiations, dispute settlements and agreement closures in UK, Europe, Gulf and Southeast Asia. He has analytical ability, logical thinking, rational and scientific and decision making, which is very most important to have to represent in front of judicial systems. He has given various lectures in the field of taxation, and he's pursuing American Certified Public Accountant course. So, sir, with this, I will request CA Amin, sir, to please present a memento.
Good evening, ladies and gentlemen. First of all, I would like to thank WARC and its chairman, CA Murtaza Kanchwala, chairman of CPE committee, CECL and CDS, Dr. Rajkumar Adukia, inspiration, CA Ramesh Prabhu, and other honorable dignitaries. in the dais. Thank you. Thank all of the audiences also for sparing your valuable time, weekend time rather, for attending the seminar on RERA. So before proceeding ahead with the how to file a complaint, let me give a very brief overview of the enactment of RERA. Though it would have been generously covered yesterday by CA Ramesh Prabhu sir. Couple of decades back, the situation was okay. The property prices were reasonable. The developers honored their commitments. The defaults and delinquencies were considerably less, or rather manageable. Post 2007, 8, 9, the property prices have almost quadrupled all over India. With the builder community getting emboldened and greedy for various reasons, they thought money was freely available. They took money from the allottees for A project, invested in B project, took money from B project allottees, invested in C project, took money from C project allottees, invested in D project. Like that, if you see each developer, many of them have 10, 15 projects under their belt. They can tap money from various sources. One is the home buyers, the banks, financial institutions, stock market. Now foreign institutional investors also, float bond papers, etc. They left, right and center, invest in the projects without completing the initial started projects. उनके तो पांचों उंगलियां घी में हैं. And who is the sufferer? All of us. To save costs, they will, if a delay happens, before that, so a parliamentary committee was constituted in 2009, which did widespread research, and it came to the conclusion that this conclusion is also shared by Bombay High Court Nilkamal judgment also, by the honorable judges, that there were widespread irregularities in the real estate sector, and there were established large-scale diversion of funds. It stopped short of terming it as siphoning of funds, but diplomatically it termed it as large-scale diversion of funds. So, and with the quadrupling of property prices, the overall impact of the defaults and delinquencies and the delays was huge. The government had to do something. Previously, there was MOFA, it's a very old act, but as you all know, there is no dedicated adjudicating mechanism for MOFA. If you want relief under MOFA, you had to knock the doors of court. And you know, when you knock the doors of court, it will take ages for relief. Even for order on paper, forget about order on paper, even for the first hearing, it will take 3-4 years. If at all the hearing comes in 5 years, the second hearing will come after a year or two, the third hearing later on, and then it goes on. The same thing was the case with the National Consumer Redressal Forum also. All were overburdened with all the other cases of global cases, like right from cell phone to etc. Goods, services, everything was clubbed together. Real estate property, all of us probably buy once or twice, if you're lucky, thrice or four times. But even for buying a property in, for say example, Bombay, 1 BHK is 1 crore, 2 BHK is 2 crore, 3 BHK is 3 crore. A normal allottee not only exhausts his current savings, but also pledges his future savings by taking home loan of 10 years duration, 15, 20 years duration, and pumps it, believes the builder, trusts the developer, and books the property. At the time of booking the property, you would have seen lots of flats, apartments. He would be in a very desperate state of mind and very high. So what due diligence he has to do, it may just blind the eye, and he trusts the builder does the book. Once the booking is done, without verification of the antecedents, background of the, you have given your neck to the builder. Whenever he wants money, he has to just squeeze, and you will all of you will be coughing up the money. That was what the scenario. And what recourse you can have? Courts, kacheri, waste of time. Kacheri mein kaun jaye? That to antagonizing the builder. So all those biases, prejudices play in the back of the mind before acting against the builder. But so whatever the builder does, we tolerate, take it as our destiny, fate, and go on. Unless everybody comes together as a group, then all of us must have the courage to take on the developer or the builder. But then, to get all of us, you may not be knowing who the other neighbor is unless the construction is complete or a gathering is over. There is a gathering. In this sort of scenario, RERA was enacted. There was widespread discontent as well. With this background, RERA was enacted by the central government in 2016. Want to bring transparency with respect to the project information. Before RERA, the real estate sector was completely highly opaque. From where, what information you will get? If you want to get, you will have to go to the BMC, check all those things, or MADA, etc., etc. Now all those details are available in a single site. Second, the promoters were going scot-free. What emboldened them, what made them do whatever they want according to their whims and fancies was lack of accountability he was responsible, he was answerable to nobody. MOFA was there on paper. If anybody had any issue, they had to knock the doors of the court. But promoters were answerable to nobody. He had to just take the permissions from BMC, NADA, etc. How he does it, what he does, all of the BMC gives the permission on an automatic basis on architect certificates. So this was enforced to bring accountability on promoters. And to overall regulate the real estate sector, was acting independently. These are the primary reasons. The secondary reasons were, which also has become the primary reason, is to protect the interests of consumers in real estate. How? By establishing, first of all, by forming a dedicated authority to regulate, and with the same authority to establish an adjudicating mechanism for speedy dispute redressal. When I say speedy, it was really, really fast. That's what attracted me from the general other spheres of, bread and butter of audit, accounts, tax consultations, and FEMA RBI to RERA. I had been to Singapore on behalf of the clients for arbitration before the courts, Dubai, DIFC, for dispute settlements, etc. Everywhere it used to take time and was expensive. Minimum 2 to 3 years it used to take, right from the day of filing the complaints. Here, just to give you a brief background, when I first filed a case in Jan 2018, complaint on behalf of my friend who was also my client, the doctor. We had met the developer 5 times. Developer means is the front phase, is managers, etc. With futile exercise. We pleaded, we begged, please give us the possession or compensate us, do something, RERA is there. He doesn't listen. They are very stubborn. No mails were answered, and still, if you seek your right, if you put an email to the developers, it won't be answered, or it will be answered with, very vaguely. They won't hit the point. They won't answer they won't redress your grievance. Jan, we filed second hearing, April 3rd hearing, the very next year. I was counting the days. In 20 days. The next complaint filed, same thing. It was really amazing. Gave me goosebumps. How can this happen in India, a place like Bombay? Even the Western countries, the world, US, UK, everybody takes pass an order. This is a civil matter. I was surprised. I thought, okay, why not give it a shot? My experiences were before Justice B.D. Kapadni, sir. He was a judicial member and a gem of a person. I'd say he was the reason I'm into RERA. So, first of all, we have to understand that by filing a complaint, we are not waging a war or a battle. We are not antagonizing the builder in any manner. just enforcing our rights, which were inherently there, but now specially enacted by the government to provide us relief. Now, we should know ignorance of facts may be excused, but not ignorance of law. Hence, one must know the law pertaining to RERA, and we should make full use of it. Believe me, a single complaint in a building goes a long way to straighten the developer. It makes him comply 100%. In one of the areas, there are 100 buildings in Bombay, it's Mada colony. None of the buildings have OC. And in Mada colony, all it goes for redevelopment. Even now, latest, in the last 5-6 years, the builder develops, delays, the allottees are desperate, they beg the developer for possession, the developer hands over the possession without procurement of OC, they all take it as it is their fate, and wait for the developer and just keep on praying for the developer to give OC. But in couple of buildings, in one building I had filed 2 complaints, in another building only 1 complaint. That complaint forced the developer to appear on behalf of, appear personally before the member, and he gave a promise. Sir, within 2 months I will procure the OC. He took 4 months, but he procured the OC and this is the benefit. The other building, because of 1 complaint, he automatically procured the OC. And out of 110 buildings, those people, those who had filed a single complaint, because of that single complaint of that single person, the entire building got OC. And when you file the complaint, it stays alive. Okay, we file the complaint for, okay, it's been delayed, we seek interest, we may seek compensation, we may seek rental, we may seek levy penalty, etc. that we will cover in depth. But because of that single complaint, not only you will get the OC, it stops, it curbs, it limits the mischief mentality of the developer. Otherwise, he'll keep on exploiting all of us. There is no limit to which he can go to exploit, or rather, exploit is a very diplomatic word. It's straightforward, point blank cheating, fraud. I got so many examples which has come, live cases. First, the builder has done unimaginable things for which even we cannot file before RERA. So, like, but if we go at the inception itself, then when we know that, okay, the default has happened, it may be any default. He has changed the plans without the consent. The date of possession is gone as guaranteed in the agreement for sale or allotment letter. Builder is used to take all the money. He doesn't. There are cases in 2014. He has not entered into agreement. Stamp duty burden. And one fine day in 2018-19, he finds that the ready reckoner value is double the value of the booking. What he will do? He is booked for 60 lakhs. Ready reckoner value is 1 crore 10 lakhs. The builder says, yes, registered it under the ready reckoner value of 1 crore 10 lakhs. Now, how will you take this case to RERA? Though he has agreed the booking for 60 lakhs in 2014, that was the value. But he has convinced the allotee to register way later in 2019. He has convinced him that you have to do under the ready reckoner value or difficult to the income tax. Many of the allottees have done. So what is the quantum? If you see, he has paid 100%. The allottees have paid 100% of the money. But on paper, as per the agreement for sale, they have to still pay 50 lakhs more. Practical. There is no limits of how they will come out with various, I think they have a lot of resources under their belt. They can, I think, for various ways of exploiting. So the moment you find a default, we can approach RERA. RERA is a very friendly forum, especially established to protect the rights of and the interests of consumers. And the law helps those who are vigilant. The law does not help those who sleep over their rights. This is a God-given right. We have to understand and enforce it. We are not waging a war, battle, etc. We are enforcing our rights. If we understand this, we will be freely, without any inhibitions or bias or prejudice in our mind, we can approach or file a complaint. If you think, array, court kacheri, is nothing. It's a forum. You don't require a representative also. The complainant can represent himself. But since we chartered accountants are already in the field of representation, we know we are filing returns on behalf of the clients, we are filing appeals, we are appearing before the tribunals, etc. So it becomes an easier task for us. The only thing we have to understand a few sections to file the complaint. And whenever a client comes, he always comes in a very resigned and retired, attitude. Kya hoga? Paisa milega kya? Kabhi milte kya? Guarantee dega to main karega. Who will give guarantee? Is there any guarantee for anything? No. The mechanism is established in such a manner that you will get the relief. There is no way once an order is passed that you cannot get the relief. May not be 100%. If you want to settle, once you get the order, then it's up to you. Up to what percent you want to settle with the builder? Okay, you don't want to have hassle, so we take an order, I have to pay you this much. You have to pay me this much. Don't pay. Settle, close. Give 10% discount, 20% discount on the order. Close. If the builder is too thick-skinned, take him to task. Take a warrant. Warrant will be executed by the district collector. His unsold inventories will be attached. You can even, if you're able to do some research, get hold of his private properties, residential house, give that details to the collector. You send notice there also. Then let us see what happens. Once it gets spaced there, the builder will come. So these are the mechanisms. Then अरे वो तो अपील में जाएगा, वो हाई कोर्ट में जाएगा, सुप्रीम कोर्ट तक जाएगा, इतना सब कौन Now, RERA is such a wonderful act. It has got its internal checks and balances to protect the interest of the consumers. Suppose if an order is passed, the developer, he wants to go in appeal. Suppose you have paid 1 crore. The developer has promised possession in 2016. 5 years it has been delayed. You are entitled to 1 crore into 10%. That is SBI highest MCLR rate plus 2%. It revolves around 9 to 10%. Say 10%. year 10 lakhs, for 5 years 50 lakhs. Once that order is passed, if the builder has to go on appeal, he has to deposit 100% of 50 lakhs before the tribunal for admitting his appeal. Otherwise, it will be summarily be dismissed. Have you complied? Deposit, then talk. Very straight. So simple. Now, by booking, we have given our net. See, the builder is at this level, we are at the time of. Once we file a complaint, we raise our level. Once we get the order at this level, then we become at par. We take a warrant, we go at a couple of 3-4 notches. We enforce it. So this is the thing. It creates a level playing field for the allottees. And this is the only forum, dedicated forum. You cannot approach, since in advent of RERA, section 79 bars other courts of interfering with matters of where RERA has jurisdiction. Suppose you file a complaint, the builder can come out with a mischief this thing. I'll file a writ before the High Court and delay this process. Cannot. High Court will not entertain. Section 79 is very clear. No civil court shall have jurisdiction to entertain, and no injunction shall be granted for any matter or process ongoing before RERA. That is a sort of protection. And why the orders were passed in 60 days? Section 29 stipulates that any matter pending before, which has come to the notice of the authority and its members, shall be disposed of within 60 days. And any matter before the adjudicating officer under section 71 shall be disposed of again within 60 days. If it is not disposed of within 60 days, that particular member or adjudicating officer has to record its reasons in writing. Why he or she was unable to dispose of the matters within 60 days. These are the protections. What more we want? If still we are hesitant to approach RERA, then I don't think even God can save us or help us. So first we need to get educated about all these things so that we can utilize for ourselves. See, this is all pervading. Everybody is affected by the exploits of the developers and the builders, mischiefs. Once we understand, we take it up, we can convince the clients also and the customers. Now, my lecture here will be slightly biased towards the allottees, but the builder also can file the complaints in the same manner and procedure. This is applicable to all. Now, going ahead. Who are the authorities to decide on the complaint? We should know the authorities before whom our complaint goes and before whom we will be arguing the matter. RERA, though it's a central legislation, it is to be enforced and it comes under the state purview. Here in Maharashtra, it comes under the direct command of Chief Minister of Maharashtra. It was enacted when Mr. Devendra Fadnavis was the Chief Minister. Now it is under the command of Mr. Eknath Shinde. For technical matters, the housing secretary is in charge. So under both of them comes the MCS chairman. Under chairman comes the members and the adjudicating officers. Previously, it was Gautam Chatterjee sir who was the chairman. Now the chairman is Mr. Ajoy Mehta. The previous past members were Dr. Vijay Sadbir Singh, IAS, and judicial member was number 2, Justice B.D. Kapadnis. Justice B.D. Kapadnis retired in March 21, post which his post is vacant, yet to be filled up. In place of Dr. Vijay Sadbir Singh, Mr. Mahesh Pathak has assumed charge, and we are pleading before the government to appoint member 2 to clear the backlog of cases which have piled on since COVID. I'll give you later the complaints and the disposal statistics. Now, why the distinction between members and adjudicating officers? The Supreme Court in New Tech judgment has divided the powers. How the authority includes the chairperson and the members. They have powers to award interest and levy penalty, but they do not have powers to award compensation. If you want compensation, damages, etc., for mental agony, whatever the XYZ reasons, you'll have to approach the adjudicating officer. Only adjudicating officer has power to award compensation. Previously, he had powers to award interest and penalty, but that has been curbed. He can only, it's the exclusive domain of adjudicating officer to award compensation. Now, yeah. No. Though complaint in Form A goes to the authority, Form B, which I'll cover in the later slides, goes to the adjudicating officer. But everything is online. Online, it doesn't distinguish. First of all, matter goes to the authority. They decide. And then if you still, after their decision, insist on getting compensation, it will be post their order, it will be transferred to the adjudicating officer. Then he will decide on the compensation and then it will come. The procedure is like that. Good question. Now, which is the basic section under which a complaint is to be filed? Complaints are filed under section 31. Just to have a gist of what section 31 says, the essential ingredients are 31(1) says a complaint can be lodged against whom? A promoter, an allottee, a real estate agent. So you can launch a complaint against these 3 persons. Why? Because they are the primary stakeholders in the real estate sector and the project. What is the purpose for which you can file a complaint? For any violation or contravention of the provision of this Act, rules and regulations made thereunder. Now, one question you may ask, what is a contravention of the terms and conditions agreement? Would that constitute a contravention of violation of laws of? Yes. For any breach of terms and conditions of the agreement, you can approach RERA for enforcing the terms and conditions of the contract, agreement for sale. Because these contracts are exclusively comes under the jurisdiction of RERA. By whom? By any aggrieved person before the authority or the adjudicating officer. So the aggrieved person we will deal in the next slide. Further, the proviso says, person shall also include association of allottees or any voluntary consumer association registered under any law for the time being in force. So, as we were dealing in the previous chapter, an association of allottee can also file. Voluntary consumer association can also file on behalf of all the allottees, group complaints, global relief, provided it is registered under any law for the time being in force. So hope all of you had a good clarity on registration which was taken in the previous lectures. Yes. Yes. You have to file a source complaint. So when you file a source complaint, the RERA will call upon the agent, penalize him, and force him to register. Whatever it suits you, you can form. Ensure that it is registered under some law. If it is registered, it is good. But if everybody is coming together or a majority of them come together, RERA will take cognizance of that. But if it is registered, it is better. It will, unnecessarily, it runs the risk of getting dismissed in technicalities and, all those things. AOP is recognized only under Income Tax Act, like the HUA. And under, as you know, the previous lectures, under Societies Act or under LLP Act or Companies Act or whatever. Yeah, just have an entity, have a registration. Best is the society. Best is to form a society. Yes, you have to file a source complaint. Huh? Yeah, that's, I will cover in the slides. After the complaint, we will be hitting the source complaint. There are many projects which are not registered, or the developer would have handed over without procuring the OC, should have taken possession also. Better you can file source complaint and do. The complaint, the form and manner of filing the complaint is prescribed under Rule 6 and 7 of the Maharashtra. It's a pretty long Real Estate Regulation and Development Recovery of Interest, Penalty, Compensation, Fine Payable, Form of Complaints and Appeals, etc. Rules 2017. We'll just short, in brief, call it as RERA Rules 2017. Complaints, again, as I told you, it has to be filed in Form A under Rule 6 for complaints before the authority, and in Form B under Rule 7 for complaints before the adjudicating officer under Rule 7. Now, it's just the Form A and B differs, but both the forms are same. So you don't have to worry about Form A or Form B. And when you file online, practically there is no distinction at all. It's straight. But we should use primarily Form A for all practical purposes. Now, who can file the complaint? An allottee can file the complaint. Now, who is an allottee? An allottee is a person who has booked a flat. He has got an allotment letter or an agreement for sale, or at least a receipt showing that he has paid money for so-and-so flat. Can all file the complaint. One fine day, I feel the builder is not responding at all. I should take him to task. I'll have to file. Or I'm not an allotee. Just see, this building is lying abandoned for quite long. One fine day, I have the urge, okay, I'll take the builder to task. I'll file a complaint. Can I file the complaint? Can I file the complaint? We cannot. The essential ingredient of filing the complaint is that you have to be aggrieved. How you become an aggrieved? By when the developer commits a default. When he commits a violation, when he contravenes the provisions of the Act, or he does not perform what he has been obligated to perform under the Act. See, there is onerous obligations put on the shoulders of the developer under the RERA. Section 11, Section 3 to 18. All these Section 3, 4, registration, disclosure, etc., 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 Section 11, 12, 13, all cast an obligation on the developer. And all the obligations which are cast on the developer by RERA translates and transforms into rights of the allottees. This distinction, we should understand this. Oh, that is only the developer to the performer. How does it affect us? No. All the obligations translates and transforms into rights of the allottees, including the disclosure, starting from registration. Once he registers, then only he will file all the disclosure documents. In a single click, you will find IOD, CC, the title certificate, the development agreement, everything you will find, draft model, sale of agreement, draft allotment letter, his, what is the cost of completion of the project, engineer certificate, architect certificate, quality control certificates, everything. So if he doesn't disclose or if he doesn't comply, say okay, ठीक है, वो तो नहीं करा, अपने को क्या करना, वो RERA देखने दो. RERA won't. RERA it goes on a self-assessment mechanism. You be vigilant. You complain to the RERA. Oh no, he is not complying with this thing. The moment you complain, even before your complaint comes up for hearing, he will comply. Should have complained. This is all. Make good use of it. Yes, sir. With source complaint, yes. With source complaint, yes. Source complaint goes on and source complaint doesn't call you as a complainant. Source complaint calls you as an informant. Yes. Otherwise, any Tom, Dick and Harry will just waste the time of RERA. And in the filing the source complaint also, yeah. Where they will go for catching hold of you and penalizing. See, it is an option is given. If you want to appear, you give all your details. If you don't want to appear, you keep quiet. But when you file the source complaint, you upload the source complaint with all these supportings also. Like you find a building which is constructed, which is not registered. You go to the BMC or MADA office, take the IOD, CC, you click the photographs, upload it, you take the layout plan, check it with an architect, upload it. That is a good source complaint. RERA takes full action against it. Suo moto also, RERA can take action. I'm coming to it. So you have to be an aggrieved allottee who has interest in the project via booking of an apartment, having paid money. Payment of money is important. Just booking, you cannot, because the relief has to be calculated. It will be calculated in the monetary terms. For that, exchange of money is important. Otherwise, there is no transaction. Having something, booking form, allotment letter, or registered agreement process. And the opposite party should have done some violation which gives rise to grievance. Association of allottees. In case of Neptune Builders Welfare Association versus Neptune Ventures and Developers Private Limited, collective action was taken by 55 buyers. And against the promoter, which was accepted by the authority. Please try. Take signature of majority, file it. Or if you want, whoever is agreeing, you can approach RERA and tell the builder is not forming an association. Tell him to give us a list of all the allottees so that we can coordinate and form an association. In RERA, I'll tell you the reason for that. No, that was in 2018 and 19. I'm 22, it's changed. There is a delay of 2 years. In 22, they are taking up matters of 2020. But if you press for urgent hearing, you file the letters, there are senior citizens, take medical certificates, attach with them. 2-3 times you file, seeking urgent hearing, they will hear. They will hear. They will accord the opportunity. Seniority. So, yeah. So I'll tell you why. If you want, I can cover. You see, in August 21, there were 15,000 complaints with 9,870 disposals. There were pending of 6,398 with 3 members. Chairperson, member 1, member 2. Now, after 21, member 2 has retired. His post is vacant. The government is not filling up the post. Chairperson, member 1. With the current status of complaints is 20,400 complaints are pending. 13,841 were filed. 13,841 disposed of, with 6,500 cases pending. Even if each member passes 100 orders now, which is the thing, it will take 2 years. But you please tell me what is your alternative. This is still, I agree. From the inception, 2018-19, there is an extraordinary delay. Because from 60 days, if you see 1 year, 1.5 years, 2 years, you will get dejected, disappointed. But still, it is the fastest comparatively. No. I'm not telling like that. You see, if you approach in a consumer forum, it will take 5 years. Here, at least you will get it within 2 years. Yes. Yes. This is the fastest. But please hold patience. This will give you. And when they give you, once the first hearing starts, the second hearing will be within next month. No. The first hearing, they would have asked you for conciliation purposes. So then it will be coming for seniority. Yeah. Yeah. Yes. Yes. Appeal to the Chief Minister. I have made an appeal. I will share with you. Put a straight application to the Chief Minister with a copy CC to the Deputy Chief Minister and the Principal Housing Secretary. Urgent need for appointment of judicial members. Kindly increase the bench strength of RERA thrice so that the backlog can be disposed of. Sir, you please then only you can expect the outcome. Have you put? Who has put? I have put. Now I will be urging our institute to put back me, my association, which I'm heading to back me. I'll be launching a signature campaign, taking 100 signatures, and then again putting it the same thing before the chief minister, and let us see how he ignores it. Huh? Yeah, PIL also can be done. I think a PIL is already in place for that. The Bar Association has already taken. So, by far, this is the best and fastest available mechanism. Believe me. No, no. See, this is a dedicated forum which has been created. So now, having made all of you aware, kindly you can put your own appeal to the Chief Minister. Now, Association of Authorities can file. The promoters of real estate can also file. Like when the right is given to the allottees, the promoters of real estate can also file the complaints. Against whom? Against the allottees. If the allottee has agreed to make the payment, he doesn't make the payment, the promoter can file. But he will not file. He will directly cancel, issue notice for cancellation, then we will have to approach RERA. But if you approach us RERA, it is good. Since all of you are already in the builder side for certifications, etc., you can, from the builder side, you can file the complaints for recovery of money from the allottees. Real estate agents can also file. Practically doesn't happen. Then, suo motu actions by the authorities. The authority, having come to know of any violations or contraventions, can suo motu assume a complaint and take action on it. In 2017, at the start of RERA, there was one famous case of Saha agents, Chembur. They put a banner without mentioning the MARERA registration number. It came to the notice of MARERA. It called up the agent. Did you do? Yes. You plead guilty? Yes. Okay. Pay a fine, 1.2 lakhs. Enjoy. You change it immediately or we'll leave the file. You change it immediately. This is how the non-compliant persons are brought online by the RERA. We have to have some trust and faith. We have to believe. Once we believe, we will get the relief. If you start with the resigned attitude, believe. Belief is good here. Who cannot file a complaint? Now, third parties who have no privity of contract in a real estate agency, as the gentleman asked. Why you cannot file a complaint? Because you have no privity of contract. Are you related as a allottee or a developer or a real estate agent? No. When you don't have any privity of contract, you cannot file. Why? Because you lack the locus standi to file the complaint. Now, second, yes. You will be mentioning, no, you will be giving to the RERA. You give. No. See, you bring it to the knowledge. If they take it, take it. Otherwise, you pay, you bring you directly to their knowledge. They will be forced to take cognizance of it if you file it by paying proper complaint. If you just like that file, it depends upon them whether to take it or not. If it is extremely serious, they will take it because they are also overloaded, burdened by the complaints and cases. Now, matters who cannot file the complaint. Now it's a joint venture, the promoter and co-promoter. developers, contractors, subcontractors. Now, let me ask you, the audience, why all these are inherent part of real estate sector? There can be no construction without landowners, contractors, lenders, developers, co-promoters. But any disputes between them are not allowed. No, that's now in these contracts, though they are an integral part of real estate sector, any contract between co-promoter, promoter, developer, promoter, landowner versus promoter, contractors, subcontractors versus promoters, lenders versus promoters, complaint cannot be filed because there may be contractual disputes, but does that contractual dispute, the question to be asked is, does that contractual disputes gives rise to contravention of the acts of RERA, provisions of RERA, rules and regulations of RERA? No. No, it doesn't. If RERA gets involved in these things, how are they to redress us? See, these are contracts, these are disputes under the Contract Act, which can be solved via arbitration or through court of law or through any other mechanism. When other remedies are available for other contractual disputes. That's why the Maharashtra Appellate Tribunal, in order of Kotak Mahindra Bank versus East and West Limited, has very clearly mentioned that any violation of contractual arrangements, the best remedy will be for them to take recourse of the appropriate statute, not RERA. RERA is exclusively for disputes between allottee, promoter, real estate agent, a triangle of these three. That is why, now let me tell you, ask you, if there are many cases of redevelopment going on. The redevelopment existing tenants of redevelopment society, they give interest matter to the building to the developer. The developer has delayed. Neither the new flat owners are getting, neither the existing tenants who are part of the property are getting the possession. So, can the existing society who has agreed, signed a redevelopment agreement with the developer, can they approach RERA? Samaj Kalyan case specifies they are deemed promoters, being landowners. So the redevelopment agreement between the existing landowners, existing society and the developer is treated as a contractual arrangement. It comes outside the purview of RERA. Though in future, maybe it can pass an order or notification and include them also into the purview of RERA. But that's a future thing. At present, they are at par with promoters. Which society makes the allottees members? That's a cooperative society. Yes. Existing members. Correct. No. Association allottees means, I'll put you like this. If you are an existing tenant, have you paid any money to the developer or have you received money from the developer? You are not paid any money. You are not booking any new flat. You are getting a flat in lieu of your existing flat. You are not an allottee. allotted a flat in lieu of what? Existing flat. Yes. Yes. You are the landowner. It is, see, either you appoint a developer to develop, or you can self-redevelop also. What happens if you go for self-redevelopment? You become allottees of yourself? Cannot. An allottee is a new flat purchaser who pays money to book a flat. Have you paid money? No. Your agreement as a redevelopment agreement at this stage is treated as a construction agreement. Please put a appeal. If that's what I'm saying. At present, this is the point of view. I agree with you. Why you should be not given the relief under RERA? I totally agree. But this is the law as it stands. For that extra, you can go. Extra only. See, if the RERA wants to provide you relief, on what basis it will provide you relief? There are two ways of relief. Okay, interest on the consideration. What is the consideration? The amount which you have paid is a consideration. The quantifying the amount of relief becomes difficult. I agree with you. You can take the ready reckoner rates as on the date of redevelopment and assume it as that's the kind you have paid. But have you paid? No. So you see, in a redevelopment agreement, if you read the fine print, you are giving your power to the developer to develop. He is developing on behalf of you. So where is the question of exchange? That he is getting from the other allottees. No, you are not paying him. So it's slightly complicated. Great. At present, the law deems the existing tenants as a co-promoter. In future, if it changes, well and good. So this is these people cannot fight, including, unfortunately, yourselves. Subsequent means recent. From I will come to that. So why complaints are filed? Usually, complaints are filed for refund of money. Suppose if the project is stalled, you can file under section 18(1) and take the entire amount as a refund. And this is called as opting out of the project. And when you do that, you are entitled to refund of the entire money which you have paid, along with interest calculated from the first date of payment. Suppose you have paid 10 lakhs in 2014, from 2014 till the date of actual refund. If you paid another 10 lakhs in 2015, from 2015 till actual date of refund, like that. So right from the first day of payment, you are entitled to interest. You are opting out of the project, you are exiting the project. Compensation or interest to the allottees for delay in giving the possession. You can opt, you can say, no, I'm not exiting the project. I want my possession of flat. There is a delay. You file a complaint. You can file a complaint for interest compensation under section 18, which will be awarded from the very next day of date of default till actual possession of handing over of the apartment. Compensation for defective title of land. This is any title defect. You can file a case without any limitation. 5 years, 10 years, 15 years, 20 years, there is no limitation at all. This is another fantastic provision. You missed some installments due to some XYZ reasons. The developer irregularly, unilaterally cancels the allotment. You can approach RERA and stop the cancellation of allotment. Many times, the developer doesn't register the agreement. He takes all the money. He's supposed to take only 10% of the money as booking or allotment before registration. He takes 30%, 40%, 50% money, doesn't register, you can file. You have been made to book due to any incorrect or false statement but given by the real estate agent or the developer, you can file a complaint under section 12. You can withdraw, you can either claim damages or you can have a complete exit also from the project under section 12. And claim of compensation for any of the contraventions ranging from section 7 to 19 of the Act. Third, you can approach, file a complaint for levy of penalty under section 3 and 4 and for any other provisions of the Act, for non-registration, for non-disclosure of mandatory items, etc. Then finally, for revocation of registration under section 7. I'll tell you one case wherein in Chembur, one of the very prominent developers there's a two-phase project. He has collected 150 crore in phase 1, another 160 crores in phase 2. He has started attracting bookings from 2014-15. Most of them were NRIs. 300 crores he has collected without entering into an agreement for sale. In 2018, he calls everybody to the registration office. He shared the draft without date of possession. Everybody comes eager to register. They all signed. They were all promised possession by 19. So they come and register in 18. After a week or 10 days, when they get the agreement, they are saying the date of possession is 31st December 2024, which has got extended by another 1 year due to the COVID notifications, etc. And still now, there is no, forget about plinth or excavation also is not taking place. Now, what is the remedy available to them? If they approach RERA, it will throw out the case stating it is premature. With 3 years to go, the developer can construct by that time. So the best thing is all of them have to come together, form an association and file for revocation of registration under section 7. Because it is inability of the developer to construct anything. If all of them come, RERA will take it up, take the builder to task. So revocation under these extreme circumstances, filing a complaint for revocation under section 7 becomes important. It was there. They signed it, everybody, without checking. Because when they sent the draft by email, it was blank. The date of possession was not there. And when they called everybody to the registration office, made them stand for an hour, do you think who is going to check all these things? They just sign in the dotted line. 300 crores. What other remedy? We filed in UOW. Taking under section 2013, which is a cognizable offense of MUFA. And other Public Deposits Act, Maharashtra, yes. Yes. Hmm. You should have filed the complaint before registration. But still, they will say they will penalize the developer and ask you to register. If you are registered already, then there is no cause of action. No, you'll have to file a complaint before registration. If you had filed a complaint before registration, it would have come to your rescue. You can file. You can file. Take a certificate from an architect or engineer or whoever contractor and file. Better. Yeah. Yeah. Yes. And before taking possession, you would have checked it also. Did you take the possession under protest or you took it? And anyhow, even if you had taken later, you would have a certificate from a contractor and then file. Yeah, I'll come to that. So, okay. So, what are the checklist of documents to be verified before preparing the complaint? Brochure, booking form, allotment letter. These three items gain significance if registered agreement for sale is not there. If registered agreement for sale is there, you can ignore these three things. Registered agreement for sale will be the binding document for everything. Then receipts of payments, if possible, try to procure a statement of ledger statement of yours in his books and have it. Home loan statements, leave and license agreements, correspondence exchange between both of you, allottee, promoter. Then main thing is go to the RERA site, verify all the documents which are submitted by the developer, which will give you a fair idea to what level of compliance he has done or not done. It will give you an understanding of the entire project as well. And you can also study, if you go to that project, you can have all the orders which are previously passed in the previous complaints. That acts as an excellent benchmark for you to gauge whether you will be successful or not. What is the authority's view on a particular complaint? It will give you an insight into how the developer is giving the excuse, what excuse, whether it is accepted by the authority, whether it is rejected by the authority, etc. So you have to compile all these documents and study it before filing a complaint. Now, manner of filing the complaint. Rule 6 states, any aggrieved person shall file a complaint before the authority in Form A in triplicate, which shall be accompanied by a fee of 5,000 rupees, which has to be paid online. Provided that where the authority makes a provision for online filing, the hard copies will not be necessary. Now it's all online, so hard copies are not necessary. Certain mandatory details are to be furnished. As per Order 11 dated 23rd October 2019. What are the mandatory items? When a complaint is being lodged for seeking individual relief, the aggrieved person must provide the building number, flat number, wing number, shop number or unit number, list of names of all owners, joint owners, so we'll take the queries later on. First we will complete this. List of all joint owners' names, total consideration value, money paid till date. It's very important to gauge the quantum of relief. Date of allotment or booking, date of agreement if any, date of possession mentioned in the agreement or allotment letter or booking form or in an email if any. So date of possession is very important. If it is not mentioned, then there are various other ways and means of catching the thief. For a failure to provide all these details, the complaint may be summarily be dismissed as not maintainable. Second, group complaints shall be entertained only in respect of common relief under section 7 and 8 of RERA, Association of Authorities. Now, there are many cases coming to the individual complaints. Individual complaints needs to be filed individually. Now, a person may own 4 flats. If he owns the 4 flats in his own name, he can file a single complaint. If he owns 4 flats in his name, one singly, one jointly with his wife, the other jointly with his mother, still he can combine because there is a common denominator. But if his brother is owning 1 flat, mother is owning 1 flat, his father is owning 1 flat, he is owning 1 flat. Okay, all of us are family. Okay, combine, we file a joint complaint. No, it's too risky. It may be, it will be dismissed. And it has to be filed in accordance with section 71 in compliance with rule 6 and 7. Now, what is a form? Form A. The blank form of format of Form A is given for ready reference. Here, this is the format, C Rule 6, complaint to the authority under section 31. You have to mention the complainant name, respondent name, address of the existing residence and the residence where you have to serve the notice. The respondent, assuming the allotee is filing, you can put the developer's name, office address and address for service of all the notice. Jurisdiction, for here you can put Mumbai. For Pune, you can put Pune. It goes like that. Project registration number. Facts. Give a concise statement of facts. What is to be included in facts? Facts, if anybody has filed an appeal, you can follow that. Here, please, it will go like this. Mr. XYZ, can mention his profession, booked so-and-so flat at so-and-so project, so-and-so full address, having carpet area so-and-so for XYZ consideration, wide agreement for sale dated so-and-so, with the developer having project registration number, dash, whatever. First para. Second, till date we have paid so much of money. This much of money is paid. Date of possession as specified in the agreement for sale is so-and-so, so-and-so. Next point, till date possession is not given. You can mention the construction is at so-and-so, so-and-so stage. He is responsive, unresponsive, you can mention. You can also mention if you have taken a loan, the allotee has taken a loan at so-and-so, so-and-so. This much of loan I have taken at so-and-so interest rates and paying an EMI of so-and-so. I'm staying in a rental, the allotee is staying in a rental accommodation. If you you are too much far away, you can also mention that the commuting due to the existing residence and the place of business is giving a lot of headaches, which will be giving rise to compensation. These are all the concise facts. Given a brief, it will depend upon the case-to-case basis. Relief sought. What relief can you seek? Interest under section 18 or under section 12. Registration of agreement under section 13 if it is not made. Compensation for mental agony, per month rental, for rental outgoes, penalty, levy of penalty for the attitude and unresponsiveness or any other violations, legal costs, etc. You can mention all these things. All you can mention. You will leave it to the authority, whatever they give, you can accept. And grounds of relief and legal provisions explained as under. Under what section you are seeking the relief, mention that section. If you catch a rule, mention that. And I will be giving you a list of case laws, which you can freely mention, especially the Neil Kamal judgment. It's a wonderful judgment. You can mention and rely upon while filing the complaint itself. Instead of providing additional submission with relying on further case laws, you can provide in the complaint itself. It will be a complete complaint. Is this enough? You can pray for interim order also, stating that till the time the complaint is adjudicated, kindly pass an order preventing the developer from raising any further demands on us. You can pray and keep quiet. Second, you have to give a declaration that this matter for which you are filing is not pending before any other court of law. Why res judicata principle applies. You cannot go for forum shopping. You can, first of all, no courts will entertain, but you are allowed to go to consumer forum or IBC. But if you have gone there, you have to withdraw from there when you file the complaint here. You choose one forum for your relief. That's more important. The amount which will be paid online, list of enclosures you can mention, verification. Whatever I say is true to the best of my personal knowledge. One more important document is the statement of payments. All of you will be having the receipts. Make a nice statement, serially numbered, date-wise, with purpose, receipt number, check number, and bank name in a nice tabulated manner, Excel. This is a mandatory statement. If you file it without this, unnecessarily one more hearing will go, or they will ask you to file this. This is a very important document. This document has to be signed by the complainant, and in this document, space is provided for the counter signature of the respondents as well. Now it is online video conferencing. Previously, it was a physical hearings were conducted, wherein the members used to take counter signature of the respondents, so that there is no dispute on the amount, exchange of amount which has taken place. And that is fixed, the quantum can also be fixed, adjudged. Vakalatnama, letter of authority under section 56. Under section 56, chartered accountants, cost accountants, company secretaries, and legal practitioners are allowed to represent. So you can make a standard Vakalatnama. Proof of service or documents is dispensed with, and make an index with duly, page it properly, make an index, and page all the documents as per the index. So, checklist for online complaints. First, you have to now everything is online. You need to keep ready your full name, email ID, mobile number, and address. And for lodging complaint, you need the project registration number, without which complaint cannot be generated. Name of promoter, address of promoter, details of your interest, which will be the first para of the facts of the case. Complaint in Form A with facts of the case, relief, compensation, grounds, and statement of payments. You have to scan all the documents and keep it ready. The scan, you can upload any many documents, provision is there, but each individual attachment should not exceed 1 MB. You have to compress or distribute it into several documents. Important aspects online for online filing is the portal doesn't distinguish between Form A, Form B. It's a standard thing. It is up to us. First, all complaints are heard by the authority only. Then it is diverted for compensation or conciliation as required as opted for us. This matter I already covered. The whole procedure and the complaint is visible online. There is no need to service. Once you have uploaded it by paying the fees, the opposite party gets access to all the documents you have uploaded immediately. Immediately email goes that acts as a service of notice, and he can access all the documents uploaded because he has registered under RERA. If the promoter files, he will have to service us the documents, otherwise we will not come to him. And he will service the documents. Scan of all the relevant documents cannot exceed 1 MB. Now, you have to online complaint IT, log in into the system with the user ID and password. It will throw a verification link of your email ID. When you receive that email from RERA, click on the verify it so that you verify your email ID. Create your user profile. Add complaint by selecting new complaint. Generate complaint number by filling the project registration number. Once you put the project registration number, the project name will appear, submit it. Immediately complaint number will be generated. Based upon that, you can proceed ahead. Add complainant details with name, joint name, type, address, email, mobile number. Briefly state the nature of project. Recapping. Respondents, it goes step by step in the portal. Add respondents details, all the details. Then comes the uploading of the documents. First will be facts of the case. You can keep on adding how much documents you want to upload. You can add. It's an option. You can add and say statement of payments. Add relevant pages of the agreement for sale. Add allotment letter. Add housing loan statement, etc. So you can go on, and finally there will be declaration and verification. The same thing. The declaration will be there online stating that whatever I have filed is true to the best of the knowledge and belief. Pay the fees to credit card, net banking, UPI, etc. All modes are available. Done. The complaint is submitted. You can opt for conciliation also. Same process is there. The link is mareraconciliation.mahaonline.gov.in. Here the fees is 5,000 rupees for conciliation, 1,000 rupee. Better opt for complaint by paying 5,000 rupee. After filing the complaint, automatically an option is there for you. The first hearing, they will be, the chairperson or the member will be asking you whether you want to opt for conciliation. If you say yes, it will go to conciliation. If it is successful in the conciliation, you can come with the order and that terms of agreement, which will take the form of an order. If you're unsuccessful, you can come back. The case will be transferred within 45 days. And you can opt for, it will be coming up for regular hearing for order. For source complaint, you have to visit marera80.mahaonline.gov.in/sourceinfo, wherein you will be providing the informant name, address, mobile and email ID, promoter's name, address, email ID, contact numbers. Only certain things are mandatory. You may not have to fill up the mandatory items only. Address, other details such as commencement certificate, current status, occupation status, photographs, approval documents, etc. Submit. Now, yeah. Just tried the there. Source complaints are very rarely filed in urban areas. Mostly it's prevalent in the peripheral areas. Now, yeah. 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 Execution. No, once the authority passes an order, it will transfer the case to the adjudicating officer for quantifying the compensation. No, 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 no separate applications. You can plead at the time of hearing. One of the landmark judgments, we will have the question and answers after the completion, because this will resolve many of the issues which you will be facing. One of the judgments which you can blindly rely when filing or upon during hearing or during arguments is the Nilkamal Realitize judgment. It's a landmark judgment. It was an eye-opener. It was a game changer. Till the advent of this judgment, the authorities were passing orders under different interpretation. After this judgment in December 7, the authorities did a 180-degree turn. Then they started passing orders in favor of allottees. Fantastic. It's a 300-page judgment. If you really want to have an overview, each and every section is discussed at length as to why this section is there, what purpose does it serve, and it upheld the constitutionality of RERA. When RERA was enacted, all the builders came up in arms. They went and filed a writ before the Bombay High Court stating that it is unconstitutional. It is against the Constitution of India. It should be scrapped. The Bombay High Court analyzed each and every section and gave a speaking judgment, watertight. It upheld the constitutionality of RERA and stated that under Section 18, interest has to be awarded from the date of possession mentioned in the agreement for sale. That is sacrosanct. Simply because RERA is started now and the possession date was promised earlier, it doesn't mean that you have to interest will start getting calculated now. It will start getting calculated from the date of possession mentioned in the agreement for sale. Second, it also stated that interest under Section 18 is not penal in nature but compensatory. Now, what effect does this have? Once you make it penal, if you deem it as penal, then it becomes subjective. It becomes a topic for, it becomes, they can take it into litigation. It becomes discretionary. Mens rea, only on culpability of offense, guilty, then you can award the interest. But it said it is not penal but compensatory. When it is compensatory, it becomes mandatory. The FAQs of RERA states that it is automatic in nature. The developer has to automatically pay you the interest in case of a default. But does he do that? No. If you want interest, you have to enforce your rights by filing the complaint under Section 18. It's a fantastic bill. Then it also goes to say that if the builder defies to pay you interest, it amounts to unjust enrichment on his part. What more you want? The developer, the builder is unjustly enriching himself. At whose expense? At your expense. Are you supposed to act gratuitously? If you are so benevolent, you can do donation. PM Relief Fund, Tirupati, wherever you want to go, you donate. But do you have to give donation to the developer? No. It goes to say, the allottees are not expected to act gratuitously. The developer who is enjoying the benefit is bound to make compensation to you. Then, the usual, the developers, the next will come, the developer and the allottees, not to escape the ambit of RERA and other stamp duty and everything, they put it as a 999-year lease. The High Court said, no, it lifted the wheel and said that there is no long-term lease and all. This is a sale transaction. And lessee was deemed to be a promoter, lessor was deemed to be a promoter, and lessee was deemed to be an allottee. It brought everybody under the ambit of RERA. Navani Bagga versus Nilkamal Realtors. Case of second sale. Suppose you buy in
from, not from the developer, but from another first purchase. In this case, the first purchase gets relieved. He gets the money from you, he gets out. He exits the project. You are in the project. So you have made the agreement with the first purchaser. There is no agreement between you and the developer. In that case, can you file an appeal? Can you file a complaint? How you don't have anything with the developer. There is no privity of contract with the developer. Here, the authority held. The second purchaser is also entitled to relief under section 18 on delayed possession, because the second purchaser steps into the shoes of the first purchaser. Right of subrogation was invoked and judgment was passed. And how the developer gets into the agreement? He has given his NOC. Without NOC, can you buy? And if you want the possession, whom will you making the further payments? The developer. He is already bound by it. Based upon all these principles, the authority passes this order. They pass a judicial order, civil order. In Anita Castellion versus Godrej landmark, see, all developers cases are there. Nobody is above, is a good. Everybody is violated somewhere. The authority held. Once agreement for sale is there, the allottee is stopped from claiming relief under section 12, relying on allotment letters, booking forms, etc. Agreement for sale supersedes the earlier agreed terms and conditions. And what supersedes everything? RERA, Act, rules, regulations. If anything is contained in the agreement for sale, which is violative of RERA, RERA will reign supreme. Yeah. Okay. Right. So before signing the agreement, you should have taken that point. If you signed the agreement, you agreed to all the changes put forth by the developer. Huh? It's very clear now. Before entering into agreement for sale, we could have invoked and took release of that. I understand. These are the things which happen. Many greater things have happened. So, unfortunately, in Middle Padia versus Larsen and Toubro, the promoter entered into agreement for sale with all the lenders, promising him, instead of mortgaging, instead of offering collateral, he entered into agreement for sale. He allotted the flats. Then the investors approached RERA. The promoter agitated, stating that no, they are not home buyers at all. They are just investors. They are lenders. RERA has got no duty. You cannot entertain them. RERA asks only one thing. You have entered into agreement for sale. If you have entered into agreement for sale, they become allottee. RERA is applicable. And all reliefs under RERA is applicable.
And simply because you got the OC,
तो 20
jurisdiction of RERA does not come to an.
20-25 लोग हैं.
That's what. If
20-25
the
लोग हैं.
building is nearing completion, pay everything, take the possession, and then take the product to task.
सब भाग गए.
Everything is possible.
वो
So if you take it,
Oh,
say,
20-25
if you file a complaint before,
नहीं हुई है.
the litigation, then okay.
वो 20-25 में भी हुआ.
Various ways and means options are available.
वापस फोन किया था आपके दोस्त ने.
Simply because you have taken the possession,
जानी दे.
doesn't stop, it doesn't act as a law, stop doesn't apply.
जाने वाले हो.
You can file later on.
नहीं अच्छा नहीं लगेगा ना तो अभी मैं ये एड़ा बन के रह रहा हूँ ना.
Then that extension is you are giving for RERA purposes. Extension under given consent of extension given by the allottees to the developer. How does that change? Does that change your agreement for sale?
कहाँ पे?
That you cannot sign.
हाँ
How?
नीचे है ना.
Even if you sign, doesn't matter.
अभी ऑडिटरी में हो रहा है.
Protected.
आना बैठ के
How? Anybody can say, okay, I will kill you, but you will not file a police complaint. Will you agree? I will do, I will snatch 1 kilo of gold from you, but you will not file a police complaint. Which goes against the law. Anything that out there, okay, I will keep it, we will do this thing. Anything violation of law is ab initio why? Straight. You sign whatever you want. Whatever the builder will ask, that you have no rights, no power. He had put, one of the very famous builders had put in the agreement for sale that none of the allottees or home buyers will approach any court of law, nothing, etc. They called me for verification. Doesn't matter. How can anybody prevent you from approaching the court of law or seeking remedy? That is your not given right, government given rights. Doesn't matter. In Rohit Chawla and others versus Bombay Realty Appellate Tribunal, there was no agreement for sale, but still allottees were granted refund with interest based on possession date mentioned in brochure. Yes, no brochure. Possession date mentioned in brochure. Possession date has to be mentioned somewhere, either in email or allotment letter or. Now we will come to a case wherein there is no date of possession mentioned anywhere. Filter is very, very clear. In this case, there was no date of possession mentioned anywhere. So the Supreme Court came to the rescue in Fortune Infrastructure versus State of Revenue. This is also a landmark decision. It states very clearly held that where there is no date of possession mentioned, a reasonable period of 3 years has to be. The date of handing over of possession will be calculated as 3 years from the date of booking. If within 3 years the developer fails to hand over the possession, you are entitled to refund or interest or whatever. All rights and remedies are available. Finally, Gauri Tatte versus Nirmal developer. Mulund case only. Wherein the Nirmal developers have taken a lot of money from all the allottees way back in 2012-13. No construction. Then Chapurti Colony intervened as a development manager. Justice Giri said that since you had the right to sell as a development manager, you also become a co-promoter and you are liable along with the main promoter to the allottees jointly. We made Chapurti Colony also liable. Very good. Nirmal developer has gone bankrupt. Visa is taking and doing what is the rules to compensate the allottees. Just protecting the allottees all aspects. In Dinesh or Umani versus Kiran estate, this is also a very good thing. Many times once you book, you are trapped. If you go for cancellation of the booking, the builder will forfeit everything. Booking they will take 5 lakh, 10 lakh, 15 lakh, 10%, whatever. The appellate tribunal held Fourth feature of booking money. This is under letter of allotment. Was prima facie unfair, unreasonable, and unreasonable. Right to reserve includes right to withdraw also. Full refund ordered. May not get the interest, but you have got the full money without any deductions. Now the authority has come out with the allotment letter format also under a separate notification, wherein he cannot collect, developer cannot collect more than 10%, and the maximum forfeiture amount is capped at 2% of the sale consideration. If 2%, if cancelled after 60 days, if it is cancelled usually within 30 days, 1%, 45 days, 1.5%. The new notification also has some. I'll share it with you. Well, no, it is valid. It is so. It's already shared. And it will be uploaded in the WARC website also within a week or as soon as possible. Then another landmark is New Tech Promoters and Developers versus State of UP, which the Supreme Court has upheld, wherein if the developer has to appeal any order passed by the authority, he will have to deposit 100% of interest and compensation, and minimum 30% of the penalty imposed by the authority with tribunal for preparing any appeal. All around protection. Supreme Court has passed this order. Fantastic. We have come to the end. We have dealt with the question and answers. For filing complaints, please, we'll take up the question and answers also. Disclaimer, do a thorough study of the Act, provisions, rules, notifications, orders, circulars, and file the complaints, overrode the authority, and put an appeal to the Chief Minister for increasing by registering also. So that all of our cases can be posted out fast in a CD. Yes, sir. See, that is a pioneer judgment is also there. In case of pioneer urban, it's a Supreme Court judgment. Supreme Court gave the verdict stating that an allotee can adopt concurrent remedies are available to the allottees under RERA, Consumer Protection Act, and IBC. So simply because the matter has gone to the IBC, that doesn't prevent RERA from adjudicating on the matter. You get an adjudication in RERA and go to IBC for recovery. Or if the matter is already there, you can join as a financial creditor. That's also possible. Claiming your money with interest there. Both the options are there. Yes. Yes. And for sole proprietary agencies also been reduced. By 10,000 rupees. Yeah.
काल आई है अपना न्याय में सीख है उन्हें कंप्यूटर्स करेंगे कई देर होगी से कई देर न्याय में न्याय अच्छी बात ना बढ़े जहाँ अपन शान को जहाँ फायदा हो अथवा मूडी नीचे के काम किया करें
approach RERA.
भैया तू कब बात करें
They will provide relief. Now they have constituted a special officer has been appointed to deal with all the projects. Mr. Sanjay Deshmukh. So he is in charge
of reviving this old project. So make an, it doesn't matter. Why all of you can take over the project and do, or you can file a complaint. They will appoint another developer, complete the project and hand it over to you. Or they will impose such conditions that they will at least to get the refund of this money.
शायद से कंफर्म ना मान सकता शायद इन्हें क्यों पढ़ाई लिखाई हुए तो आज के काल सोई नहीं शायद से इतना पूरा क्लियर ना मालूम बट पूरी करने पर चला जाए
See, all of them who are booked in Nirmal, they are booked way back. The whole
नहीं उन्हें वो
yes,
तो भी इनके नाम अनीस वो है ना अनीस वो से भी हराम लाइक अनीस वो और प्रियम पिंकी थोड़ा दर्द कोई आए थोड़ा बलामो लगाई उसमें और इतना लगा बरन चुना लगा बड़ा है कि छोट है किसी की नहीं आई चाहे सरिता है अपने आप की बड़ी की जनक करी तो है कहबे करी अरे भाई मगर
because both of you agree,
कहा करती
it becomes a
में कैसे रह जाए
contract. If you dispute, you are fine with RERA, you agree to it. Matter is closed.
चाहे पूछे चाहे दीदी हो चाहे चाहे दीदी ने चाहे चाहे कुछ खाओ फिर अपना चाय निकालो पी के हटिए प्रियंका यहाँ चला प्रियंका जब दिमाग खराब है तब
You will have to take
दीदी आवा चाय पी दीदी आवा चाय पी
cost benefit, risk reward ratio, analyze all of
बट अपना निकाल पी के चल दे सकते खाई निकाल चल दे
But you have to take a decision based upon whether the new product will be able to deliver.
आप आए देखे अगर तुम्हें चार दिन बतावत है तो समझ में आवत है तो हम बोले उन्हें सेगमेंट वो देखी जब तक वो आई तू बन गए पंडित मत बने तू भाई कारगान हमारे तो 4 दिन पढ़ा नहीं है बेटा अगर रूबी से कह दिया या अपनी बात पे चलो हॉस्पिटल नाम लिखा हुआ बाटे कि नाम दिलवा हुआ बाटे कि नाम लिखा हुआ बाटे तो करण से करण चाहे हमसे करे चाहो हम तो नाम नहीं लिखा हो गया तो
Depends upon the cost, the benefits to you. If it makes the developer comply, at least to a certain extent, wherein it eases your life to approach it. Yeah. No.
नहीं अरे वो कंपनी चाहिए इसलिए मालूम है इसकी गाड़ी से पैदा करनी
Interest.
नहीं वो झुका ही नहीं हम चल रहे हैं सब करिए
it is all a desperate for possession. If you without OC, it is illegal to take the possession without OC. But under the guise of without possession, he gives you. He never will take the pain of getting the OC. Because for taking the OC, he will have to shove out like 1 km of the size of the building. He will not do. He will just go away, walk away. You can take him to the amenities, half the amenities will not be there, or cheaper, inferior quality will be used to save the cost because it is delayed. Yeah, you can take it. Yes, you can. The society, the global thing, the society can find.
वहाँ तक ना मगर भैया
Of the time you would not have formed the society, even if it is formed, you would not have handed over. You would have promised closed parking, but you would have given open parking. Many things are there.
मैं चाहे पूरे बात में फिर तो बतावा तो क्या कुछ करें
You approach the RERA, then the RERA wants interest, you can set off your dues.
अरे
Otherwise, then both are in default.
मालूम बात है
It depends upon who approaches the RERA first and gets an order. Whoever approaches the RERA, you are not paid, you will be in default. Better you approach the RERA first.
चैन जेबा से भरे
You get an order, they declare he is in default.
जॉन्स खानदानी भाई से तो कपड़ा करते चैन अंगूठी पहने रहते हैं ना दोनों जॉन सारे 4 दिन पहले सर के लेके सर चैनल को बनवाए रहते हैं, उनमें सारे भरे निकाल के लेकर घूमते हैं।
Yeah, defect liability is there.
तुमने
5 years. But defect liability is 5
तुमने
years.
अच्छा नहीं करना चाहिए।
Date of OC. OC possession model. Usually OC is their possession in.
नहीं तो तुमके शर्म आवे चाहे कि अपने भैया से बतियाते किसी
Globally, the defect liability there is a sharp
यार बात
focus.
करता है पर एक बात है तो उतना सब बात है तुम उन्हें
Yes. Hope you enjoyed the session. Thank you. Anything you can get in touch with me with my number. Thank you. Yes, email ID, number, everything is. Thank you.